Coalition for Healthy Society, and 2 other members, individuals who will also be making presentation later. We have some apologies for absence. I think we have apologies from Senator Donna Scott Motley and Mr. Dwayne Smith, but a number of persons have indicated they're coming online. I know at the moment we have Minister Cuthbert Flynn and Senator Shereen Golden Campbell will be joining us as soon as she can get on. The minutes of the 3rd and 11th of March 2026, we are going to leave until the next meeting. So we'll ask at the next meeting that those minutes and the one today, we'll ask everybody to try and read those minutes so we can confirm them at the next meetings. But with quite a number of presenters who will be here, I think it's best for us to begin. And we're happy to welcome first the DPP herself, Ms. Claudia Thompson, and her team who have joined us, and immediately after the Office of the Children's Advocate, and welcome the Children's Advocate herself to Mrs. Gordon Harrison. Yes. So, DPP, we are going to ask you to just introduce your team, and then you can begin.
Good morning. Claudette Thompson, DPP. With me is Dwayne Green, Assistant DPP. Next to him, Elaine Henry, Legal Officer. And joining us later will be Deborah Bryan, Assistant DPP. The presentation will be made by Mr. Green.
Okay. When you're ready, Mr. Green.
Good morning, good morning. I crave a moment. I'm just trying to share my screen here. I'm looking. I'm not seeing that option. Oh. Where we are. It's being... One second. It's being blocked and this thing isn't coming. Yep, here. This one? It's, I think the toolbar stuff.
We're just starting.
I mean, I don't have a challenge with it, looking like that.
Presentations are actually down here.
Oh.
It's okay if it gets anything, then we just have to try hard.
No problem.
Ready?
We'll try to. I'm not looking at things.
This thing really dislikes me. Yes, good morning again, everyone.
Right, go
Honourable
ahead.
Minister, Members of Parliament, specially invited guests and presenters. This is the presentation, or submissions, I should say, on behalf of the Office of the Director of Public Prosecutions. Now, I believe we're all familiar with the Child Diversion Act, which is titled or labeled Act 4 of 2018. And this piece of legislation really assist in the criminal justice system where dealing with child offenders are concerned. But I must extend my gratitude to be invited here to comment on some of the issues and recommendations that we would wish to highlight and make in relation. I crave a moment.
We're trying to get a bigger screen to get it fully on the full screen.
Very well. We're grateful, Minister.
Minister Dalrymple, the minutes we put
All right, thank you.
deferred until the next meeting. So we'll take at least 2 minutes at the next meeting. Okay, no, they're not succeeded?
Yes.
Oh, wonderful.
Yes. Very well, Minister. Now, our submission is from the standpoint of practitioners in the criminal justice system. This is a piece of legislation that we use a lot, and it varies depending on which parish you are in. Now, for persons who pay attention to the statistics that our office will present at the opening of each term, you'll know that some parishes have higher numbers of children being in conflict with the law. Now, what this piece of legislation has enabled us to do, instead of having to try a minor, hope that there's a conviction, make submissions to the court as it relates to how the sentencing process should be treated, the option of diversion has created a new dimension. That is, the children can be diverted from the regular processes of the criminal justice system so that they can be dealt with in a more unique and centered manner that can cater to and deal with their specific needs. Now, as we're all aware, most cases start in the parish courts. However, from our experience, diversion usually takes place in the circuit courts. Now, what that actually does, it creates a delay. And I'll touch on it now, but as I go through my presentation, I will go over it further. One of the issues highlighted with delay is that the offender is placed before the court when he's 16 or 17. Now, when you encounter a circuit that has 300 matters for 4 weeks or 400 matters for 4 weeks, when it does get to his day, he's 21, what that now creates is, can he now be sent to diversion? He would have lost out from the benefit of the program itself from all that time that passed from he was 16 years of age until he's 21 years of age. So these are some of the issues that we have highlighted in terms of when diversion actually takes place. Because I believe, and we believe as an office, if we're able to address, for example, the delay issue, we can make this legislation more practical, we can make it more beneficial. And I think one of the hallmarks of our legal system is consistency. We want to ensure that everyone is given the same fair opportunity to benefit from the system. So, for example, one person should not be able to benefit simply because his case got called up before another person. And these are the issues that we wish to bring to this chambers.
You want us to deal with that first, or you want to finish?
Well, we could
finish. You're finishing
right.
then.
Because based on how we have structured our presentation, we have a section dealing specifically with the issue of delay and what recommendations can be made to address the issue.
Okay, go ahead.
Now, as I've been indicating earlier, the purpose of the Child Diversion Act, and we have here, remove certain children from the formal criminal justice system. Additionally, it emphasizes rehabilitation over punishment, and it prevents unnecessary criminalization. It also promotes guidance, accountability, and reintegration. But what does all of that mean in the context of a child? Now, you've heard persons say oftentimes a conviction and a sentence usually does not deter crime. Crime is a social issue. Crime is an issue that you need to get to the root of why it is that this person is before the court. And I believe that this Child Diversion Act, what we can focus on is the rehabilitation aspects. You don't have to take the child through the entire gamut of the legal system. You can get them from they come in, and you can identify what are the reasons or issues that led to this particular child being here today. Now, there are pros of the legislation. One which is, children who engage in criminal activity do not receive criminal records and are provided with guidance on relationships and addressing underlying issues. Now, I must comment on the impact of a criminal record. Now, as a society, we do believe in rehabilitation, but oftentimes we've heard of persons saying, listen, this person has a criminal record, I'm not hiring this person. So the reality is, the prevention of a child receiving a criminal record will assist that child greatly in the future. You get to be dealt with in a stage early on in the proceedings. Whatever the issues are that led to you being before the court, that issue can be dealt with and addressed. Once you're successful, you're removed from the system. There's no record of it, and it's not held against the child. And I believe that is in the true spirit of rehabilitation. Further, we have misguided children receive supervision, guidance, and discipline. And children are given opportunities for advancement, and they are prevented from early exposure to hardened criminal environments. And I want to comment here for a bit as well. For anyone who has been inside a courthouse, for example, the Home Circuit Court downtown, everybody's in the same space. The murderers, persons accused of rapes, persons with gun possessions, the human traffickers, all persons are kept in the same space. Now, we are of the view this is not an environment for a child. So if we can get the child out of that environment from early, that is a benefit to the system. Now, nothing goes without criticism. Part of the criticism of this legislation perhaps could be that the state is accepting criminal behavior or that it is encouraging social deviance. But our response to this criticism really is that the welfare of the child must be considered, and also the long-term societal benefits of rehabilitation. And for persons who have practiced in the family law jurisprudence, you'll be familiar with the phrase, in the best interest of the child, and that the interest of the child is paramount. Now, again, if you can identify what the reason is for the child being in this position in the first place, then you can prevent it from happening. You'd have effectively solved a repeat offender situation. You'd have effectively created a scenario where this child can receive further mentoring and guidance in relation to whatever social issues contributed to him or her being before the court. Now, from the practical standpoint, we have identified what we call a core issue, or core issue number one, which is the acceptance of responsibility as stated in the legislation. Now, before I can get on to why must a child accept responsibility, I must comment on how it is actually done currently. The child comes before the court, a recommendation is made by the DPP that this matter should be sent to diversion, and the child is then asked to accept responsibility. And then this is done by way of a guilty plea. Now, that creates a legal issue, which causes us to now say, why does the child need to accept responsibility? As practitioners in the justice system, we should be able to assess the file, assess the evidence against the child, assess who the complainant is or are, what the needs of this particular child is, and send the matter to diversion. Because the reality is, not every child will appreciate what accepting responsibility means. Not every child will appreciate that, okay, I can benefit from the diversion program if I accept responsibility and I go to the diversion program. Oftentimes, what you might find when children are in deep conflict with the law, for example, those who find themselves in criminal organization or who associate themselves closely with elements of criminal organizations, they see the system or they see the justice system as an oppressive front. They don't want to have any part of it. So you have to break down that wall first before you can actually get to dealing with the issues that are now facing this particular child. And if they are going to be faced with the decision to accept responsibility, what you might have is, instead of diversion, you have a trial. What you might have is a conviction. What you might have is a sentence. That child goes into the penal system, serves his or her sentence, comes back out, no better than he went in before. And then we are back there 2, 3, 5, 7 years later. So if we remove the requirement of accepting responsibility, a holistic assessment is done by the relevant stakeholders. And in this case, I'm speaking about the DPP, the police, or even the judge. Then we can have more matters being sent to diversion.
He wanted to finish. He wanted to finish, and then we'll get a chance to.
The second issue with the child accepting responsibility by way of a guilty plea is that there's no requirement in the legislation that the court must dispose of the matter after the child successfully completes the diversion program, because what is before the court is a guilty plea. When a person pleads guilty in the context of a criminal justice system, you are saying, okay, this is what the Crown is saying against me or the state. I accept what the Crown is saying against me. It is true, I did it all. And I'm confessing, I'm taking responsibility for it. But the reality is, or the problem is now, after a guilty plea comes usually sentencing. There's no requirement in legislation, as we are saying, that the judge must dispose of the matter after the successful completion of the diversion program. And what that leaves is the child remains exposed to the prejudices within the justice system based on how it is currently set out. Now, we've identified a further inconsistency, I should say, within the Child Diversion Act. Now, different persons can send a matter to diversion. Based on legislation, the police, before even charging a child, can refer the matter to diversion. When the matter comes before the court, prosecutors have to make a recommendation to the judge for the matter to go to child diversion. Now, we find that a bit of an issue dealing certainly with the decision to prosecute. The DPP's powers under the Constitution of Jamaica, because at the end of the day, if we are looking at what the legislation is designed for, we are trying to remove as many children as possible in the interest of justice should the circumstances fit, to put them to the diversion program so that their issues can be dealt with in a particular and unique way. But if all the prosecutor can do is to make a recommendation to the court, but it means that the court doesn't have to listen to the prosecutor's recommendation. The court can say, well, I disagree. The matter should not go to diversion. Let's go to trial. But again, if we are really looking at the spirit of what is contained here, it too follows a decision to prosecute. The DPP will have to ask herself or her agents acting on her behalf, is this a matter that I should prosecute? Or is this a matter that should go to child diversion? Now, the further complexities of the situation arises where, for example, the judge says, no, I am not sending the matter to child diversion. But then it is the very same prosecutor who held the view that the matter should be diverted who will have to try the case. So I believe that's an issue that we will have to zone or should be zoned in on and looked at. The other issue as well is that it creates somewhat of an unfair treatment to children in the system, meaning you have one child offender who meets a police officer who says, I'm going to divert your matter before you are charged. But yet another child is charged and placed before the court and is at the mercy of a recommendation. So again, that's another issue, I should say, that we highlighted that I believe should be zoned in on. I believe that the prosecutor should have the option to refer a matter directly to child diversion. Now, continuing on what the current practice is, where the child pleads guilty, we have seen instances where the court has asked the prosecutor, after the child successfully completing the diversion program, to offer no evidence. Now, that creates a legal discrepancy, if we want to call it that, because when a person pleads guilty, they're accepting the evidence that is contained in the statements or material that forms the basis of the charge. On what basis is the prosecutor, in the remit of criminal practice and procedure, offering no evidence on a guilty plea? Because you are saying that all you have said, so let's use, for example, sexual intercourse with a person under the age of 16. Complainant is under 14 years of age. The accused is 16 years of age. He says, yes, I had sexual intercourse with her. I am pleading guilty. It happened on the 20th of January, 2022. It happened at X place. I met her at Y place. I'm taking no issue with it. I am pleading guilty. On what basis will the prosecutor be offering no evidence? And seemingly, it seems inconsistent with the criminal practice and procedure, because after a guilty plea, usually comes a sentence or a sentencing hearing. And just to add as well, dealing further with the inconsistencies with the treatment by way of the police having the option to divert some matters, whereas other matters have to go by recommendation. A child should not be required, in our opinion, to plead guilty to plead guilty to access child diversion. Now, we sought to make some recommendations as it relates to how this legislation can be improved, certainly where the requirement of an admission is concerned. And we're saying that there needs not be a requirement for the child to plead guilty or accept responsibility. The decision to divert should be based on evidence in the file, circumstances of the offense, characteristics of the offender, and the interests of justice. And as I indicated earlier, that the assessment can be made by the prosecutor, or I should say, be made by the prosecutor or the police. Now, another issue that we highlighted is how matters are disposed of after the child has successfully completed the diversion program. Now, and I crave a moment. The legislation in its current fashion indicates that the court makes an order that the child is discharged. Now, in the context of the criminal justice system, a court usually has no jurisdiction over an accused person, or even the decision to prosecute or not to prosecute. The court's jurisdiction usually comes in after a person has been arraigned. So, for example, a judge can stop a case at no case, on a case of, a submission, of no case to answer. Submissions can be made by counsel for the court to use its inherent jurisdiction to make certain orders. But in the general criminal and practice procedure, the decision to prosecute lies with the prosecutor. So if at the end of the completion, I should say, of the child diversion program, that the child is not to be prosecuted, that decision really should be made by the DPP or the prosecutor, because again, if we're looking at it from the perspective of the interest of justice and the best interest of the child, so the child has completed the program. This is an offense that did not offend public moral or offend society in such a grave way to warrant a trial, then by all means the prosecutor, acting as a minister of justice, would make the decision whether or not to prosecute. But as it is contained here in now, the decision rests squarely with the judge. Crave a moment. So what we have recommended, what we have recommended is, for example, upon successful completion of the child diversion program, the Director of Public Prosecution, or I should say a prosecutor, would indicate to the court that it declines to prosecute the matter and would thereby offer no evidence which would bring the matter to a complete end. Now, crave a moment. What we have also as well, so the legislation speaks to what we call divertible offenses, and it refers you to the first schedule that says what the offenses are that are referred to as divertible offenses. But then there is a general discretion clause, as I refer to it, under section 37(2), which says that it grants the judge the discretion to divert any other offense. No, what we have here is it doesn't say how the judge should go about exercising such a discretion, and it doesn't even say if there is a limitation as to what offense or offenses can fall under Section 37.2. And what we have seen is, for example, offenses such as rape, burglary, and grievous sexual assault that have been diverted pursuant to Section 37.2 of the Child Diversion Act. Now, we're not saying that there should really be a limitation, because each case must be assessed on its own merits. The circumstances of child A who finds himself charged with the offense of rape may very well be different from the circumstances of child B who finds him or herself charged with the same offense. However, guidance is needed as to how the court should go about exercising its discretion, and how the stakeholders in the decision-making process as it relates to whether the matter should be diverted should go about making that determination. Now, as I had indicated earlier, in relation to the impact of delay and child diversion, what we have found, or what we are recommending, is that diversion takes place at the first point of contact, which is usually the parish court, save and except gun court offenses. So the matter comes before the parish court for a committal proceeding, or for the matter to be prepared for a committal hearing. Once the matter comes before the court, the prosecutor and the parish court should make the determination whether the matter should go to child diversion. Once the child successfully completes the diversion program, the prosecutor and the parish court should then have the matter sent to the circuit court for the matter to be disposed of, if the offense for which the child was charged is an offense that lies only in the circuit court. Because what we would have is that for offenses such as rape or sexual intercourse with a person under the age of 16 years, the parish court would have no jurisdiction to dispose of that matter. And we're of the view that dealing with the issue, or having the prosecutor and the parish court be the first point of contact in making the determination as to whether the matter should be diverted, will alleviate the issues that now prevail, where offender is 16 years of age at the time of the offense, and by the time the matter makes its way to the circuit, he's now 21 or 20. I believe if that determination is made from early, we can mitigate against that issue. Now, in concluding, we are of the view that the refinement of the legislation really will ensure that there is fairness. It will further protect the rights of children, and most importantly, it will promote consistency and public confidence in the child diversion program. And these are my submissions.
Mr. Green, I want to thank you and to thank the Office of the DPP for an excellent presentation. I have about 30 questions, but before I ask them, most of them, I know members are eager to ask questions, but I would just like DPP to ask just one question first, and then I turn it over to the members, and I will return with other questions. But the program at the moment allows for constables to not to charge and to refer the child to child diversion. That's the one process. The second process is that for the court. Now, you have intimated, and I think this is where we want to go with the legislation, that the DPP, once a charge has been preferred by a constable and sent it to the DPP, instead of taking it to court where the child has to come to court, that the DPP will put in the legislation that the DPP, on her or his own, can refer the child to child diversion, and if the child goes through a successful 3-6 months, the DPP can say, we're sending you in for 3 months. They will have to accept responsibility at that point, and they will go and say they will go 3-6 months or a year, and if you complete the program and the child diversion officer confirm that the program has been successfully completed, then the DPP would then drop the charge. In other words, will not proceed. That would avoid what you have been saying, that the child intermixing with the court at a trial going to court, because we want to keep the child away from the formal justice system. Yes, there will be other cases where the DPP thinks it may not even be in the schedule, but you would like the court, let us say it is rape, a 16-year-old. The DPP might feel, I better take it to court and ask the court to do the referral, recommend to the court that they do the referral. But there are other matters like minor matters, that the constable has charged, comes to the DPP. The DPP might even wonder why did the constable even do that? Why didn't they just send the matter to child diversion? But if it comes to the court now, and this is where both the children's advocate and I have had feel that accept responsibility doesn't necessarily mean guilty plea. You accept responsibility on the basis that I will proceed to child diversion. Unfortunately, the courts have interpreted accept responsibility to mean a guilty plea, but the legislation, when the children's advocate, we have discussed it, say that accepting responsibility, it still allow you or the court to refer to child diversion without the guilty plea. Because if you plead guilty, why are you going on child diversion? Because you're going to have that hanging over your head. And as you quite rightly say, if the child does go on the program, completes it successfully, then the court is in a conundrum. What do you do with that guilty plea? You see, it's a major problem, which the Chief Justice has pointed out. We must, if you want to change the interpretation, and we intend to make it very clear that the legislation, doesn't require the child to plead guilty. It may well be, as you have suggested, that we do remove this take responsibility. But the truth of the matter, you want that term because the child has to accept that they've done something wrong. So the requirement, DPP, which I hope you will confirm, that we want that the DPP can directly refer the matter to child diversion. Okay?
Minister, not to beat the dead horse, but this presentation really has only two pillars. One, we want to be able to refer matters as opposed to just making recommendations, which is less power than the constable has.
Yes.
And I'm not being heard? Oh,
no,
sorry.
go ahead. Yeah.
And secondly, how does the child demonstrate his acceptance of responsibility? We would like for that to be cleared up, because as has been said, if demonstrating responsibility in a criminal setting requires a guilty plea, then whether you have gone to diversion or not, you have pleaded guilty. On what basis in law then does the DPP stop the prosecution
Absolutely.
or end the prosecution?
I'm glad.
So we'd like some clarity.
Sure, and I'm going to ask you, if you don't mind, I know you have to go, but to hear the children's advocate, because
we're
I think
here.
she has some proposal on that too. So before I even ask it, I want my team, I don't want to hog the show. The children's advocate is going to make her presentation afterwards, and I'm sure she will respond to some of the concerns that have been expressed by the DPP. But Member Buchanan.
Thank you, Chairman. Mr. Green, I think I'll direct my questions to you as you were the presenter. I'm not so sure if I agree with you that it is the judge who has the final say in terms of disposing. The act, as I understand it, would say that when the child completes child diversion, then the matter pretty much is disposed of automatically, isn't it? Yes? On the basis that the child diversion is done. I think the only difference is where we have the guilty plea dilemma. But where most of the cases where you divert, the matter simply comes back to say that the matter is completed, and that's the usual course.
The problem that's the DPP, sorry, Mr.
Yes.
Green and the DPP is confirming. You're put in a conundrum because
with the guilty plea,
right?
No, well, I'm sure that the Office of the Children's Advocate would, based on their recommendations.
Yes,
but
yes.
I was saying that the strengthening, the things were said in relation to Section 37, which is one of the sections giving the judge, notwithstanding, in the interest of justice, to divert matters. That is important because you have, as you rightly said, but we have to appreciate that you take your child as you find her, so that it is in the context that the access to diversion in circumstances where the crime is not a part of the schedule, that a judge in his or her wisdom would find that, notwithstanding the child before me and the circumstances or the facts as sensitive as it is, would still warrant the diversion.
All right, give DPP, you wanted to respond to that?
Yeah, if you want to respond to that.
Go ahead.
We're looking at Section 11. Are you there?
Mm-hmm. Go ahead.
Where it says that criminal proceedings shall not be instituted or continued during the period of the child's participation in the program. That flies in the face of Section 94 of the Constitution. It's not the court that ends a matter.
Right.
It is the prosecutor that ends
Exactly.
a matter, and the court discharges the person.
Okay.
Yeah.
Okay.
So that's the point we were attempting to make.
So you see what the DPP has emphasized from the presentation of Mr. Green, the legislation needs readjusting.
Work. All right.
And in other words, because the DPP at any time can withdraw any charge against a person. So to the extent that we need to put in the legislation the opportunity for the DPP, before she withdraws the charge, the opportunity for the child to go through a program of child diversion, and if successfully completed, then the DPP then can exercise the option to withdraw the charge. So if the child fails to complete the program properly, the DPP can proceed. So we need to make sure that that is in the legislation.
So then I understand, Chairman,
go ahead,
is to give the DPP, which I think we're all already agreeing, the power to refer, and rather than recommend, but also I'm again defending the right of the judge to access 37. Because I saw where you said it, you highlighted it as a concern, a serious concern, because diversion has occurred in cases involving serious crimes.
Well,
so
the DPP, if I might, I think I got from Mr. Green that there, in many of the parishes in particular, perhaps 20% or more of the cases could in fact not come to the court if they, and the delay would be stopped because from they get the file, say in many of these parishes, a recommendation could be made by the DPP to go to child diversion, and the child is on child diversion for 3-6 months or whatever period of time. And when it comes back to the DPP, if the person has completed the program satisfactorily, the matter is dismissed. Now, where we have a nuance is that the DPP may well see a serious charge, and I think Mr. Green pointed out to that, like, say, rape or a gun. The child is found in possession of a gun, and therefore, out of a public interest, the DPP might well take it to court and recommend for the court to then move it to child diversion. So the point I'm really making, it's a discretion of the DPP. We want to give the DPP the discretion to, as we agree, to divert as many as possible, but the DPP should still have the option in the public interest to say, here, this youngster, 15-year-old, has been found with a gun, but we still believe this child can benefit from child diversion. We are going to ask court that we send it to child diversion.
I just want the DPP to confirm that that's what they're saying. Is it that you also want that power, Madam DCP?
Yes.
Very well. All right. Thank you.
Any other point? Go ahead.
Mr. Pizzo, Mr. Chair. Just for clarification, Section 9 of the Act speaks to delineates the persons who have the jurisdiction to refer. And it speaks to the court. So referral to child diversion, section 91A, the
Yes.
court. Just for clarification, the court here, in terms of its interpretation, would be who or what? The judge,
It would be the judge.
prosecutor?
The judge is the court.
So it is the judge specifically when it says the court. Now, just a question here. I've had some experience, in the courts, and I've had to deal with some of these cases, and I've had the experience where the prosecutors actually made the referrals, actually indicated to the judge. I've had a case where the prosecutor looked at the case itself. It was already in the court, though, I would admit, and indicated to the judge that based on their review and perusal of the matter, they think it's a matter fit for diversion.
But the truth is, it's a recommendation.
Yeah, and they made a recommendation. So in other words, now you're proposing a sort of what I would say now
A hybrid system.
For that now to be incorporated in the legislation. So it needs to be codified now. That's what we're saying.
Is in the legislation.
Yes.
What we're asking for
You
is a
want the-
power to make a referral.
Referral. So in other words, it will be independent of the court.
Yes.
For
Correct.
referral. Another question I have. So if we should, and I take your point that to actually capture a child, because we understand the issue of delay, so you would want to, you're recommending that the parish court now, where the matter usually, some of those matters, the matters that fall within the act itself, that they are dealt with from the parish court level. So, logistically now, when those matters comes to the parish court, that would be solely decided by the judge and the clerk?
No, the clerk would have to refer the matter to the DPP.
That's the question. So the matters now, so when those matters come before the clerk of court, as to the question of diversion now, then it has to be referred to the DPP. That's what you're recommending?
Yes.
Yes.
Okay.
In other words, any referral, a direct referral, must be guided by the office of the
Office of
DPP.
the DPP.
In other words, the clerk of court, in my view, should not send directly to the diversion. It's the office of the DPP that should assess the evidence and make that recommendation.
So you're
Otherwise,
saying that,
clerk
so
of
you're
court-
saying,
Yes.
so the court and the clerk itself, the clerk of court and the judge, the parish judge, do not have that jurisdiction to refer them to diversion, independent of the...
No, they can,
Yes.
but we are suggesting there should be no need for it. What we're saying is that the clerk of court may well see a situation where this is a matter that he or she would recommend directly to diversion without taking the child to court. But the clerk of court should not be able to do that on her own. It must go to the office of the DPP. For the DPP to send back to the clerk, we will send that child on diversion. No, the clerk may well take it to the court and ask the court, based on the recommendation, and the court can actually do that referral. But we are saying it is in the best interest of the child that is not done, that the DPP makes the referral directly.
So we are saying then that the parish court and the clerk then could not or will not, based on the proposal that the DPP has a final say, that the parish court judge and the clerk of court independently cannot refer a matter to diversion. Is that what we're saying?
We're not saying that. We're saying that in any matter, it must come under the hand of the office of the DPP. You're with me? In other words, we don't want a clerk of court to recommend directly to child diversion. The clerk may well say, no, this is a court matter, and take it to the judge and beg the court to refer to. But I'm really hoping that in all of cases involving children, that the matter be dealt with by the DPP before anything. Once a charge has been laid by the constable, all of these children's matters across Jamaica should be referred to the DPP for the DPP to determine whether it goes to the court for the referral or he or she, the DPP, makes a direct referral.
So isn't
No,
yeah,
I think Minister Dalrymple wanted to.
I agree with the approach of it going straight to. The only difficulty I have with that is the element of delay. Because once it comes, you understand, the important thing is, as you say, the child is, the age is close. So it means that time is of the essence. So once it goes there, it needs to go directly to the DPP's office and to be handled right away so that the child gets the benefit of starting that program there. And so by the time 2-3 months and the circuit court is coming, you would have had a report as to how the child has progressed. Because a lot of the times where we have a difficulty is the delay that we have in courts.
And in fact, that's what Mr. Green pointed out.
And of course, you know, Chairman, if of course our clerks fall directly under the DPP, you know, they are not in the court system anymore, but they answer directly to the DPP's office. It gives the DPP more power to relay to them, and they know exactly what she's expecting, and things would happen.
Absolutely.
And it would go directly to their office
right.
and speed up the process.
I mean, Chairman.
I'm up to you. I know Senator Shereen Golden Campbell would like to ask. Afterwards, the next to you, Senator Golden Campbell. Go ahead.
So we're not asking, just to respond to you here, we're not asking for any powers to be taken away from anybody, from the court, the judge, or anybody. We are saying the police can refer, the judge can refer, allow the DPP, allow the prosecutor to refer as well. That's one. Two, the matter comes into the parish court. If jurisdiction lies in the parish court, so the file speaks to the offender being charged with the offense of simple larceny or unlawful possession of property, jurisdiction lies in the parish court. That's a decision the clerk of court can make.
Okay.
If there is also a concern about delay, the established protocol in the DPP's office in terms of our relationship with the clerks, because clerks are prosecutors as well. They're trained prosecutors, trained attorneys. The turnaround time for ruling has always been 2 weeks, and that has not changed. And we tend not to breach that. So it is normal for a clerk of court to write to the DPP for guidance, for a decision to be made. So we're not asking that anything new, different, or unusual be done. Where jurisdiction lies in the circuit court or the Supreme Court, then we are saying diversion is done before the child attains the age of majority, because that addresses the issue of delay. And once diversion is done by way of the court below, the matter is then sent to us for formal disposal. Because remember, the power to dispose of a matter is vested in the DPP.
Quite.
Not
Wonderful.
The court. I think that should
Thanks. Absolutely. Thanks, DPP,
what it is we're trying to
for the
say.
clarification. Senator Shereen Golden Campbell. Are you on, Senator Golden
Chairman,
Campbell?
are you hearing me?
Yes.
Hearing me, but you're not seeing me. Here we go.
We're not seeing you. We're seeing you now.
Yes.
Go ahead.
Okay. Thank you very much, Chairman, and thank you to the DPP and Madam DPP. I'm so sorry I'm not in the chamber today. I've not met you yet. I wish you God's blessings and tidings on your journey as DPP. I have two questions, and the first one, sort of piggybacking on Member Dalrymple Philibert's question. Can you share with us, when a child is charged and comes before the parish court in the current circumstances, and that offense is one that has to go to the circuit court, typically, where is that child in the system? Is that child at home? Is there a bail process? What is happening with that child? That's my first question. My second question is in relation to your comments on the Section 37 to discretion that the court has to refer a child in respect of offenses that are not part of the specified offenses schedule. And I noted in your presentation that you wanted that discretion to, the criteria on which that discretion is exercised to be specified. And you said it should comply with 9.2, section 9.2. My question on that is that I understand you to be saying that certainly for 9.2 paragraph A, that provision that where the child must accept responsibility, I think you're asking for us to do away with that. Tell me if I'm wrong. So
yes,
to clarify that.
I think Mr. Green suggested that.
One moment, Chairman. If you could just clarify that for me. And the second part of my question is, what is the criteria that you would wish to see set out in section 9.2 upon which 37.2's discretion should be exercised?
Thanks, Senator Golden Campbell. DPP.
Right, so to answer your first question, in the parish court, the child is charged. He does come to court. He's placed in the dock. The question of bail arises. He may be admitted to bail, he may not be admitted to bail. If he's not admitted to bail, then he's placed in a child facility. If he's admitted to bail, then there are conditions of bail. He comes back to court for plea and case management hearing, trial readiness hearing. In the parish court, the child will come to court for trial, and it is hoped and expected that the first time he comes, his case should be tried. That's an expectation. I don't know that that actually happens there. Mr. Buchanan practices at both levels, so he's perhaps in a better position to say whether or not his case is tried on the first trial date. What I've explained to you, though, it means that the child will be coming to court, certainly more than once.
The second,
Madam DPP, just on the back of those comments, then,
yes.
In the situation where the matter is one that is likely to be referred, or whether it is the DPP, well, in this scenario, it would be the DPP who, under the current legislation, would be wishing to make a recommendation that the child be referred to the diversion program. Our children, whom the DPP see in that light, are those some of the children that are not granted bail? In the circumstance of a grant of bail or not?
I don't know that I can answer that question because there are different reasons and bases for bail, for a child being admitted to bail or not. And I don't practice in the court below. I can't tell you the last time I was in the parish court. So I'm not in a position to answer that question.
My concern, of course, would be if we're looking at a case that is a case to be diverted, I would hope that child would be permitted to access bail. But of course, I do agree. I mean, it's not about the offense. It's really about whether or not the child is going to present themselves for court. Perhaps that's something, Chairman, that we can ask.
It's the offense and the circumstances of the child. So it's both.
Right. So perhaps, Chairman, my question can be researched with the technical people at another time. But I'm interested too in hearing, DPP, your considerations about the criteria for the exercise of the court's discretion under 37.2.
Mrs. Cole Jarrett would like to respond briefly. She's actually the one who has been very involved with the child diversion program. Go ahead.
Thank you, Minister. Just a clarifying question. So the police, where they deem the charge fit for, or the offense fit for a caution, at that point can refer the child to child diversion outside of the matter actually going to court. The clarifying question I'm asking is this, based on the desire to have the prosecutor independently refer the matter. Where the police refers the child to child diversion and that child fails the diversion program, The police then has the option to charge the child for the diversion offense. Where the child is charged and that child appears before the court having failed the diversion program, the Act currently stipulates that the court is to inquire as to why the child would have failed the child diversion program. If it's not due to the child's own cause or circumstances beyond the child's control, the court has the discretion to send the child back to diversion. If you read the Act thoroughly, whether or not it's the child's fault, the court still has that discretion. So what I'm asking is this: based on what the DPP would have put forward, is it that the power that the prosecution is to have is on the first instance of the child coming before the court not having done diversion before? Because if the child failed diversion and is now charged, is it that the prosecutor is going to still have that discretion to say that I want to send the child back, or should that still remain with the court?
Good question. Very good question, Ms. Coulthard. What do you think? In other words, you got the point. Yes.
I heard the comment and the question. And I wouldn't want to limit the discretion. What I will to say is that the first instance, definitely, and then we'd like to know why it is you're saying the child has failed, or why is it that the child has failed. We'd like to interrogate that reason
absolutely,
first.
because you may want to interview the child. Sometimes, I must tell you from what I'm hearing, sometimes it's parents' fault. The parents don't get the child going to the program as often as possible. So I would agree that we should still leave the discretion to the DPP to even refer the child to another mentor. You're with me, Ms. Coulthard? In other words, the fact that the caution by the constable was not successful in that particular program of child diversion, I have no doubt that the DPP's office may well want to interrogate to determine whether or not it should be tried again. You're with me, Ms. Coleman? So we will leave that discretion to the DPP, okay? Rather than just taking it straight to court. Go ahead, Ms.
So we're excluding the court again in that instance. So if the child failed on the original diversion program and now comes before the court, it's not addressed by the judge directly.
It is. I don't like the idea of excluding the court. People might get.
Well, for want of a better phrase, it's not going directly before the judge to make that determination.
I think I want to emphasize that the child diversion is to do everything in the best interest of the child to see if the child can go straight without it having to be dealt with by the court. Because when it is finally dealt with by the court, the likelihood is that you're going to get maybe some strong penalty being imposed, you see. In other words, everything under this program should be done to assist the child.
Exactly.
That is the most important point. Yes, Member Buchanan.
Chairman, I just want to stress that this aspect of it, I just want it on record that it is important that no power is limited in relation to the DPP
Absolutely.
on this point. And here's why I say this. Adults before the court, they do mediation, fail. They do restorative justice, fail. Both the court, the DPP, the defense attorney, sometimes we say go back outside. The facts on the file is so clear.
Yes.
And they are adults and they participate in these mediation, restorative justice multiple times.
Right.
So you can imagine that an officer may have made the attempt, pass it on to the DPP, and a judge may still say, I'm going to try this one more time because we take the child as we find them.
Absolutely. Member Williams?
Yeah, I was just supporting the point that supporting the DPP's position that, giving the DPP that power to refer, even at the point where diversion had failed before, is another tier, another level of scrutiny, which would, as we said, achieve the objective of doing all we can for the child. So I would support that particular level of scrutiny.
All right, thanks.
Chairman, please, can you just allow the DPP to comment on my question relating?
The second part, what would you do instead of taking, if you were removed taking responsibility, what would you want to be there?
Well, it's not an if or then question, Chairman. I was actually really carte blanche. What criteria the DPP would wish to see inserted in legislation, the basis of which a judge would exercise discretion under 37(2).
When I thought of that point,
Not hearing her, sir.
No, go ahead, no. No, it's okay, go ahead.
are you hearing me now?
Yes.
Yes.
When I thought of this particular point, I hearkened to the Bail Act, where when a judge is considering bail, the Bail Act actually outlines the different considerations. I'm saying if these offenses do not fall within the schedule, then, and you're going to be sending this matter to diversion, you ought to outline the basis or bases on which you're doing the unusual, for want of a better word.
Okay.
Because at the end of the day, the power to prosecute is still vested in the DPP.
Correct.
So if you're going to be saying, do not prosecute, divert for offenses that the legislation does not automatically say you should divert, then you ought to give reasons. There ought to be a basis. Yeah.
Very well.
Thank
And
you,
you don't want to
DPP.
go any further, DPP, to say what kind of bases you would wish to
Oh,
see?
dear goodness. The one that
I'm
jumps to
pressing, but
mind
I don't
immediately-
necessarily need an answer
Oh.
now. I'd love to hear your perspective on it if you want to send us something.
In other words, I think Senator Golden Campbell would like to say, if we remove the phrase taking responsibility, what would you want to insert instead? Because
Chairman, you keep saying that. That's not my question.
Go ahead.
I accept that the DPP wants that part removed. I am asking now, what should 9.2 say? Not just that paragraph A, but what should 9.2 say that the judge must observe when she exercises the discretion under 37(2)? I think
So
the DPP
I would say
understands.
remove A, and I'm not saying anything. It should be replaced with anything. And I don't want to speak for the children's advocate.
I'm going to get the
but in
children's
our-
advocate
in
to
our
give us some
presentation-
idea.
Yes, in our presentation, we have said, to be fair, whether a child is accepting or not accepting, because they don't even know the consequences of doing one or the other. You are a
DPP,
child.
I accept that,
the
you know.
offense
I
falls-
accept that. I accept that should
Yes.
come out. And I
Right.
agree with you on
and
that
I'm saying
point.
it shouldn't be replaced with anything. A shouldn't
Right.
be
So
replaced
let us
with
so
anything.
let us take it out.
Yes.
It's not replaced with anything.
Right.
But there's other criteria that you're saying should be inserted in 9.2, the basis on which the judge exercises discretion under 37(2). And right now, the only other criteria we have is the prima facie case, consent of the
consent.
victim, consent of the child in the presence
rest of
of
them
the
don't affect
parent, guardian, or whatever. What other criteria are you contemplating should be put into 9.2 to allow the judge to send a child to diversion for an offense not specified in the
Oh,
act?
I see.
And I'm putting you on the spot, and I don't need an answer today.
Okay.
So I'm happy
All right.
to get
So
an
you'll give me
answer
some time
later
to
on
think
if you.
about it.
All right.
I would
Go-
appreciate
Thank
DPP
you.
if you would send us something just to put our minds in the direction.
I see.
Okay,
Thank
Member
you so
Williams.
much, Mr. Chairman.
Thanks.
Yeah, I'm just saying, Mr. Chair, that since the DPP has the ultimate, and that's a profound point, the ultimate authority and discretion whether to prosecute, if it is that an offense, if it is that the court has that discretion then to include an offense that is not in the schedule, then should this be done in consultation with the DPP, or or should the DPP?
No,
in terms of,
I don't think you want to come. No, I don't think you want to compromise the DPP's powers.
But there must be some basis, because as Madam Prosecutor is saying, Madam DPP, is that they have that ultimate decision, and they would like to I think where Senator Golding is getting at is what would be the bases? Is there any basis, or what's the yardstick to determine? So is it that the ultimate discretion is with the judge to say, well...
No. The ultimate decision is the DPP. The DPP can, at any time, can decide not to prosecute.
And I think that's where the clarification needs to be.
No, but the DPP does have to give a reason. Sorry, you wanted to say something?
Yes, the discourse between the goodly senator and the DPP in relation to 92A, I don't understand 92A to be saying that the accepting of responsibility is a guilty plea.
Well,
and so I know the Office of the Children's Advocate is going to make an attempt to clarify that, but removing 9A would be so problematic.
All right.
Because
you know,
I'm just saying that because it's so closely related to how 37(2) functions. That when I raised the issue earlier, Chairman, I was of the view that the DPP was saying that she also was to be added to 37(2) in terms of having that power to divert offenses that's not in the schedule. And then when someone asks for the criteria is in the interest of justice in the context that you take your child as you find them.
Okay, thanks.
Thank you.
Thanks, Member Buchanan. All my questions are leave until the DPP, until the Children's Advocate, because we did have a seminar. And a lot of the points raised were discussed with a seminar with the several judges. So that Children's Advocate, I'm going to ask you to just name your team, and then, and unfortunately, we're not able to get it on the screen because, for whatever reason. But so we do have the presentation amongst ourselves. Okay, So you go ahead, and we are going to ask the DPP if she doesn't mind remaining until after, so that if you don't answer the question in your presentation, I will do it. Okay, go ahead.
All right, thank you very much, Mr. Chair. I'll see how best I can collaborate with my former colleague. So I am Diane Gordon-Harrison, Children's Advocate, and with me are Mrs. Kian Park, to my immediate left. She's the legal policy manager within the Office of the Children's Advocate. And next to her is Ms. Shamsi Green, who is the senior legal policy officer within my office. So I do apologize for the members who are online that the presentation and submissions as prepared by the office are not readily available for you to view. I assure you your hard copy is here in the chamber, but we will have to deal with my oral presentation, and I hope I can clarify anything that arises thereafter. So,
just to say, Madam Children's Advocate and Chairman, the copy of the office's presentation was sent via email. Okay.
So you have it. They have it.
Copy, yes.
Yeah, they have it.
Yes.
Okay.
Okay.
Thank you very much, Member Golding. All right, so I'll start, Minister, as I usually like to do, with just a context, not just on the issue of child diversion, but more broadly on the issue of juvenile justice, because I believe that's where child diversion is contextualized best. So, as you are aware, members of the committee, the Office of the Children's Advocate has as its primary focus issues which may or actually impact upon children. And therefore, we wholeheartedly welcome this invitation to make submissions that we hope will assist this Joint Select Committee of Parliament in the review of Jamaica's Child Diversion Act. Juvenile justice as a whole has as its main objective the rehabilitation of children who are in conflict with the law. And that's not by accident, because the real view is to ensure that these children will ultimately be reintegrated into society with the ability to lead constructive lives. The underpinning rationale, as far as we see it, therefore, is that the system recognizes that the period of adolescence, and we do note that our age of criminal responsibility starts at 12, and children age out once they hit 18, so that is prime adolescent period, and that period is particularly prone to experimental behavior, which tests boundaries and can result in unintended antisocial consequences, some of which may end up infringing the penal law. It is perhaps the same perspective that has caused child diversion to evolve as a concrete alternative to the formal criminal justice system for the treatment of specified offenses. We have them listed in our first schedule to the Act. And this process of diversion allows children who find themselves in these situations with an opportunity to access meaningful intervention without automatically being exposed to the stigma that is associated with formal engagement with the full scale of the criminal justice system, and of course the risk of having a conviction and facing a sentence of the court. I will say as well, Mr. Chair and members, that child diversion doesn't only benefit the child offender who could be diverted, but it benefits society as a whole. As the DPP said in its presentation, when children are exposed to hardened criminals and criminogenic attitudes, it only prepares them to reoffend in the future, which becomes a burden on the society as a whole. Now, there is support for the position that we're putting forward today, and we have referenced the United Nations Convention on the Rights of the Child, to which Jamaica is a state party, so that means there are certain obligations that we bear. And Article 40 of the UNCRC says that where possible, children in conflict with the law are to be dealt with without resorting to judicial proceedings. This is an inescapable inference, in my view, that diversionary mechanisms are the preferred method once appropriate. The relevant portions of Article 40 are to be found in 40 paragraph 3, which provides verbatim. States parties shall seek to promote the establishment of laws, procedures, authorities, and institutions specifically applicable to children who are alleged as, accused of, or recognized as having infringed the penal law. And in particular, in paragraph B, whenever appropriate and desirable, measures for dealing with such children without resorting to judicial proceedings, providing that human rights and legal safeguards are fully respected. Similarly, from the international arena, the UN Standard Minimum Rules for the Administration of Juvenile Justice, more popularly known as the Beijing Rules, expands Article 43 of the UNCRC by encouraging diversion from judicial proceedings in Rule 11. The relevant portions of Rule 11 state, in paragraph 1, consideration shall be given whenever appropriate to dealing with juvenile offenders without resorting to formal trial by the competent authority. And of course, here, commonly that means the court. And in sub 2, it says the police, the prosecution, or other agencies dealing with juvenile cases shall be empowered to dispose of such cases at their discretion without recourse to formal hearings in accordance with the criteria laid down for that purpose in the respective legal system, and also in accordance with the principles contained in these rules. I pause here, Mr. Chair and members, to say that paragraph 2 seems therefore to have no issue with the prosecution, here the DPP's office, also having the opportunity to divert if it deems it so appropriate. Within the international arena, child diversion is seen and accepted as a viable method through which portions of the juvenile population that find themselves in conflict with the law can be rescued by access to programmatic responses that are effective. The Office of the Children's Advocate shares this perspective, and the recommendations that we will make today are made within the context of preserving the efficacy of Jamaica's local child diversion framework and also identifying any necessary means through which to improve its application. Of course, as I'm a slave to the statute, I've merely cited in the submission the authority that the Children's Advocate has to be making these recommendations pursuant to paragraph 11 of the first schedule of the Child Care and Protection Act, which says that we shall keep under review law, practices, and policy, and also make recommendations and give advice to Parliament. And we proceed to do that today on that authority. There are 6 recommendations, members. The first 4 deal with the substantive act, and the final 2 deal with the 4th schedule, which seeks to amend certain other pieces of legislation. So I'll deal with them chronologically as they appear in the written submission. The first recommendation is that Section 9 of the Child Diversion Act should be expanded to specifically state that any reference to a child accepting responsibility in a manner in which a referral to the Child Diversion Committee is being contemplated by the court does not mean, and I repeat, does not mean that the child is required to plead guilty before a referral can be made. The issue, and why we have made this recommendation, is that one of the primary concerns arising from the operation of the Child Diversion Act, which the Office of the Children's Advocate has had a front row seat, not only in practice, but in terms of assessing some of the difficulties that have arisen, is that we have seen firsthand the inconsistent interpretation and application of Section 9(2)A, which establishes as one of the prerequisites for referral to a Child Diversion Committee that the accused child accepts responsibility for the actions that led him or her to be charged and placed before the court. In practice, this accepting responsibility has been interpreted in either of two ways. So we have seen that the child is compelled to make a plea of guilty to the offense before the court, but we have also seen in other courts, both at the High Court and at the Parish Court level, where the child admits responsibility to the offense to the child diversion officer without being required to enter a formal guilty plea. I've set out in the submission the justification for my recommendation that we have it explicitly included that it does not mean a guilty plea. If we examine Section 2(3) of the Child Diversion Act, it provides, and because of its importance, I'm going to read that section in its entirety. Section 2(3) says, "This act shall be interpreted and administered so that the best interests of the child is the paramount consideration and in accordance with the following principles. A, criminal proceedings are not to be instituted against a child if there is an alternative and appropriate means of dealing with the matter. And B, unless the public interest otherwise requires and subject to this act, any child who has committed a diversion offense and accepts responsibility for that offense shall be considered for admission into a child diversion program." Now for the discussion of the problem, which I believe is really the fundamental issue before this committee. Focus is being placed on the words within this provision that have been highlighted above for emphasis, and these words are criminal proceedings are not to be instituted against a child, and also the issue of accepting responsibility. These are critical to the overarching objectives of child diversion. It is a settled principle of juvenile justice that child diversion presents an alternative to traditional formal criminal justice practices and procedures, and child diversion is aimed at rescuing the child from the usual outcomes once certain criteria, as stipulated by our statute, are satisfied. Child diversion stands as a bar to the typically employed responses of the court, law enforcement, and other stakeholders within the justice sector. Within this context, therefore, careful consideration must be given to what the underlined words mean. And in this regard, there are two salient issues that I have uplifted as being worthy of being addressed here. The first is what constitutes criminal proceedings in the traditional sense. And the second is what does it mean to have a child accept responsibility, particularly where the child has already been charged and placed before the court, and the issue of child diversion is only then being considered by the court. If we consider the aspect of criminal proceedings, the traditional criminal justice system is comprised of certain basic facets. And the three main components, as we're proposing here, can be summarized as one, law enforcement. We all know that this is the first point of contact, and it is responsible for investigating crimes, gathering evidence, and apprehending suspects with the aim of upholding public order. Next, you move to the next rubric, which is the court system. This component acts as the venue for determining legal culpability. It relies on an adversarial process featuring public prosecutors who represent the state and defense attorneys who represent their accused, their client, with a judge managing the various processes, adjudicating on legal issues, and in some instances acting as judge of the facts when they preside alone. In other cases as well, there may be a jury that seeks to fulfill the role of a neutral fact finder. That is, they act as judges of the facts. And then the third component of this traditional justice system, criminal justice system, are the correctional services. And this sector manages individuals who have gone through the process and now stand convicted of crimes. It focuses on punishment, deterrence, and rehabilitation through imprisonment, probation, and parole. It should be clear from these components, therefore, that if a child appears before the court and any procedural steps are pursued in relation to that child that constitute any of these usual criminal processes outlined above that are aimed at establishing criminal culpability, this would be consistent with the court having instituted criminal proceedings against the child or the police. And therefore, it would be incongruous with the legislative intention as expressed in Section 2.3 of the Child Diversion Act regarding how it is to be interpreted and administered. Section 2.3a stipulates that once an appropriate alternative exists, criminal proceedings ought not to be instituted against a child. Now, when we look at those three components and the usual traditional criminal justice response and consider that against the principle of what it means to accept responsibility, we really have to look at both principles together. So consequent on the foregoing discussion regarding the non-institution of criminal proceedings against a child in appropriate circumstances, the manner in which the acceptance of responsibility for a diversion offense is communicated to the court so that the court can then be referred to child diversion must be considered very carefully. Now, Jamaica's Child Diversion Office, as per the Ministry of Justice's website, is recorded as saying that in child diversion, accepting responsibility for their action means a child merely acknowledges their involvement in an offense and demonstrates a willingness to engage in a rehabilitation program. My emphasis, without necessarily making a formal admission of guilt or a plea of guilty in court. It is a requirement focused on accountability, remorse, and rehabilitation rather than punishment, aiming to correct behavior while avoiding a criminal record. And I pause in reference to what's on the Ministry of Justice's website to say that this formulation of words, which I fully support, and the submission goes on to indicate why, makes the Office of the Children's Advocate very comfortable with the continued inclusion of Section 9A. Because if a child is to really benefit from the diversion program and the interventions that come with that, there has to be some remorse, there has to be some acceptance of responsibility that I now need to pursue corrective behavior to deal with the underlying issues that may have triggered me to respond in this way. So we want to make it very clear that the Office of the Children's Advocate has no difficulty and wishes really to see Section 9A preserved because there has to be some acceptance of responsibility. The MOJ continues to say that child diversion does not require a plea of guilty. It says the key aspects of accepting responsibility is that it's not a guilty plea. It's merely accepting responsibility in a restorative way. The act must be saying, I am willing to take responsibility for this action, which allows them then to participate in the program because there's been some expression of remorse. There has to be, of course, a willingness to participate, and this signals the child's readiness to participate in a treatment plan that's often personalized towards the child's requirements. And there's a focus on rehabilitation and this serves as a starting point for addressing the root causes of the child's behavior and for rehabilitation and reintegration into society. The Ministry of Justice's website also goes on to say that there should be voluntary participation, often with the support of a parent or guardian accepting responsibility for the offense. And the website goes on to say that these steps should help a child understand the consequences of their actions and should provide a second chance at a productive, law-abiding life, preventing the negative consequences associated with the formal criminal justice system. Now, this submission agrees fully with the position here expressed that the acceptance of responsibility within the context of child diversion does not require a formal arraignment of the child, because that's a traditional criminal justice response, and it does not require a guilty plea being entered by the child. To do so would effectively indicate the commencement of criminal proceedings within the courtroom against the child, thus treating him or her as a typical offender and one who will be saddled with a criminal conviction whom the court would be at liberty to sentence in any manner it deems suitable. Undoubtedly, the approach of obtaining a guilty plea from the child engages these traditional criminal justice procedures, which the Child Diversion Act clearly stipulates is not how the act is to be administered or interpreted. There is further support for this position, as articulated in Blackstone's Criminal Practice, published in 2026, when it sought to address the effect of a guilty plea. And this particular paragraph is cited in support of the Office of the Children's Advocate submission. And it says, effect of guilty plea. If the accused pleads guilty, the prosecution are released from their obligation to prove the case. There is no need to empanel a jury, and the accused stands convicted simply by virtue of the word that has come from his or her own mouth. The only evidence the prosecution then need call in the ordinary case is that of the accused's antecedents and criminal record. Additional support for the position that extracting a guilty plea from the child as a means of satisfying this requirement of accepting responsibility is inimical to the spirit and objectives of the Child Diversion Act is contained in the very legislation itself. Sections 10 and 11 of Jamaica's Child Diversion Act exemplify the inimical position if we were to accept that a guilty plea was the way to go. Sections 10.1 and 10.2 speak to acceptance of responsibility and that admissions made as a prerequisite for a referral to a child diversion committee ought not to be used in any proceedings against the child. If the child pleads guilty, is then referred to a child diversion committee by the court, but for whatever reason is deemed to have faltered whilst on the program and has to be brought back before the court, the guilty plea that has been recorded against the child prior to the referral stands, and in practical terms can be used in the proceedings against the child. The process then becomes less advantageous to the child, as he or she would be deprived of the opportunity to explore a defense at trial, and the issue of withdrawing a plea is left within the discretion of the court, thus in our submission prejudicing the child's right to a fair trial where they are deemed to have failed to satisfactorily complete the diversion program. This is in stark contrast to both the provisions and the intention of the Act. For its part as well, Section 11.2b comments on how the court ought to treat a child whom it has referred to the Child Diversion Committee and that child has successfully completed the program. And it says that where that child has successfully completed the program and the child has been charged, the court shall then make an order dismissing the charge. This makes the intention of the statute clear. A guilty plea results in the child having a criminal conviction recorded against him, which is incongruent with the intention of this section. Once there is a conviction, the court would be left with the shambolic shenanigans and various inconsistent and perhaps impractical options to then seek to retroactively dismiss the case against the child. So again, we ask that it be made categorically clear in Section 9 that yes, we must accept responsibility to benefit, but that does not mean entering a plea of guilty. I promise you the other recommendations will go through a lot quicker, but that was really my core issue with this particular statute.
We are not complaining.
Yes. Recommendation 2, again focused on Section 9, is where recommending that Section 9 be expanded to incorporate a mandatory referral system or mechanism that requires a constable who has cause to suspect that a child has committed a diversion offense listed in the first schedule to the Act, which is what we're going to say victimless and minor in nature, to refer all such cases to a child diversion committee once the general prerequisites of the Act for making those referrals are satisfied and there are no care and protection issues that may need to be addressed by the relevant government agency or the court.
Just to point out, when you say victimless,
yes.
In other words, there's no one complaining as such, save and except. Victimless, they're always victim, yes. Like property.
Yes,
the child may have committed larceny. The yes. child may have done, say something outrageous,
yes.
curse bad words and that sort of
yes.
thing.
Yes.
So just for those listening online, the yes. victimless means that there's no individual who has suffered any harm
particular
or so
harm,
on,
yes.
Right?
And I've defined it in the submission as well, Minister.
Oh, you did.
Down.
Sorry,
yes.
I didn't realize.
Yes.
Go ahead.
So I went on to say that the amendment to Section 9 that we're proposing should also be accompanied by a proviso within Section 9 that requires the constable to provide written reasons where he fails to make a referral in these circumstances. To answer your question, Mr. Chair, it is significant to note that the meaning of a victimless and minor crime as referenced here applies where there is no identifiable victim that has suffered any particular harm. And examples of such an offense may include the peddling of sweets or wipes on the road, noisy and disorderly conduct, cursing bad words, littering of the street, etc. Of additional significance is that this proposed amendment does not seek to disturb the other powers of the constable as outlined under the Act. We have no issue with the constable's ability to issue an informal warning, a formal warning, or a police caution, and we in fact encourage the police to continue to utilize these options as appropriate. Why are we making this particular recommendation? The issue as it currently is that the permissive language in Section 9, which allows broad police discretion in referring matters to diversion, it says that they may refer, has resulted in the underutilization of the Child Diversion Act at the first available option. Our justification, therefore, for making this recommendation is that the police are first responders, and as a consequence, they are usually the first point of contact with the justice system for a child who is suspected of having committed an offense. Therefore, they represent the first opportunity for the system to pursue an alternative to the traditional criminal justice response in appropriate situations. Where this diversionary approach is not taken at the earliest opportunity, once the necessary prerequisites are outlined, as outlined in the Act, have been met, it tends to prolong the child's contact with the formal justice system and reinforces the possible negative outcomes of trauma, educational interruption by having to come to court repeatedly for various mentioned dates, and of course, stigmatization. This is not consistent with the overarching principles of this regime of child diversion, and it is an unbending principle that child diversion posits of shielding those children who ought properly to benefit from such an approach. So why wait when it's very clear when you pick up a youngster, for example, who is selling wipes? He's just walking with his wipes. Why put that child through the process of charging and then going through all of that instead of seeking to divert? So the insistence of the Child Diversion Act that where appropriate, criminal proceedings ought not to be instituted against the child, alongside what I've cited as the international perspectives as exemplified in the UNCRC and the Beijing rules that were previously discussed in this submission, they support greater utilization of diversionary mechanisms earlier on in the process. Diverting a child at the pre-charge stage would be more consistent with the objectives of child diversion as compared with diverting after the child has been charged with a criminal offense. The incorporation of this obligatory referral by the police in appropriate cases, as per the conditions outlined in this recommendation, would promote the act being utilized as intended by helping to shift what may perhaps be a cultural practice within law enforcement that is not routinely predisposed to embracing the concept of child diversion, but rather law enforcement is more attuned with the long-established formal criminal justice responses. So we may have to include this expansion to help culture along, is what we're saying. The third recommendation is that we're proposing, and we're not very heavy on this, but I raise it because the opportunity has been presented, but to look at Section 22(5) of the Act that deals with informal warnings. And we're proposing inserting that even though no record of an informal warning issued by the police is required, and we're fine with that, a record may be kept if the police so determine. As worded, required, it says it's not required, but so that means that it may be. But what we're seeing in practice is that the police are having a little bit of angst about how it's worded. The issue, therefore, is that the absence of any note by the police as to who these children are that they have issued informal warnings to presents a situation in which the police may be unable, and they have said, particularly those in the community safety and security branch, that they are unable to recall whether they have had cause to informally warn a child before, or Constable X may be on patrol, may warn little Johnny, and then Constable Y is on patrol and warns little Johnny. But because they're both informal and they don't have a note at the police station, they're not aware that little Johnny is coming up on the Richter scale for needing some kind of intervention and support or a chat with their parents, perhaps. So if this occurs, the police are limited in their community policing efforts, which results in a reduced benefit to interventions that may be directed towards the particular child. The justification for this recommendation comes from consultations convened with the police by the Office of the Children's Advocate, with inclusion of the Diversion Office from the Ministry of Justice, to discuss issues relevant to the implementation of child diversion. These consultations revealed that the police have a desire to know who these children are and prefer a note being kept at the police station. This submission, as I said before, recognizes that the provision as currently drafted does not in fact bar the police from keeping a note, but there seems to be some angst about the current formulation and use of the words "no record is required to be made or kept." The fourth and final recommendation in relation to the substantive act is to incorporate into Section 27(2) a requirement that where a constable is conducting the interview of a child victim to assess the impact of the offense on him or her so that he can know whether he's going to agree with diversion, that this interview be done in the presence of a counselor who has experience working with children and not just in the presence of the parent or guardian. The issue with this particular situation, which has led us to make this recommendation, is that a parent or guardian may not be suitably qualified in assessing victim impact, or may be qualified but so overwhelmed by the circumstances affecting their child and thus impeded in their ability to dispassionately and appropriately guide their child. The justification, therefore, is that there must be a balancing act that maintains the balance of fairness among various cohorts of children who the act treats with. In this instance, the child victim's best interests must be considered in all the prevailing circumstances, and efforts made to ensure that any processes pursued do not negatively impact that child victim. So we're saying that a professional outside of parent or guardian should assess the impact of the offense on that child victim before the child victim can properly agree to pursue that the offender should be allowed to pursue child diversion. The final two recommendations treat with the fourth schedule to the Child Diversion Act, and that schedule seeks to amend other pieces of legislation. And the two recommendations that I've made touch and concern the Corrections Act. We're proposing to incorporate into paragraph 12 of the fourth schedule to the Child Diversion Act a requirement that a psychologist or a social worker has some input into the preparation of the child care plan that the manager of a juvenile correctional center is required to create. The justification for this is that the elements that ought to inform the foundation of such a child care plan are listed in paragraph 13 of the fourth schedule, and they stipulate as follows. A child care plan shall be prepared having regard to the best interests of the child, the physical, mental, and emotional health of the child, the educational, behavioral, and social needs of the child, the needs of the child in respect of rehabilitation, prevention of recidivism, and reintegration into the community on release from the juvenile correctional facility. Where necessary, the child's participation in counseling, anger management programs, behavioral therapy, mediation, and restorative justice programs. A review of these mandatory elements for inclusion in the care plan reveal that they are heavily skewed towards the need for input from a psychological and therapeutic perspective. While the skill sets of the manager of the correctional center are not being questioned for a moment, the creation of the plan would undoubtedly benefit from the infusion of viewpoints from professionals who have the specific expertise in these matters. The final recommendation is to incorporate into paragraph 14 of the fourth schedule to the Act a requirement for the child offender to benefit from the guidance of not only a parent or guardian or an attorney at law who happens to have their case, but also the advice or input of a social worker prior to being asked to agree to the contents of his or her child care plan. What is the justification of the Office of the Children's Advocate for this recommendation? Firstly, it should be noted that the child care plan is created to guide the child's sojourn throughout the correctional facility, with diverse elements aimed at prioritizing his or her best interests and rehabilitative prospects that should support the child's ultimate reintegration into society as a functional member. Many of the elements of the plan require the perspective of a professional who is au fait with factors that support the mental and emotional health of children, as well as the particular behavioral and social needs which a child who is the subject of the care plan being developed may have. The requirements of paragraph 14, as presently worded, place the onus on the child to consider the elements of his or her care plan at the outset of his or her time within the correctional facility. The Act stipulates that this must take place within 14 days of arrival at the facility and requires that the child indicates agreement or concern with the details contained in this proposed plan. The child's response is therefore critical, and this, of course, is a weighty burden that the child must deliberate upon. The response, therefore, should at least be properly informed. It should be accepted that a child in these circumstances, having just arrived at a correctional facility, having been presented with a care plan within the first 14 days, would reasonably be expected to be overwhelmed emotionally and otherwise, and may not be in the state of mind to purposively assess the contents of the proposed care plan and comfortably indicate their considered option or opinion. This child's best interest we're submitting would be better served if they had the support of an individual specially trained in this area and equipped with the necessary experience. While there is no opposition that the Office of the Children's Advocate has to the parent or guardian or attorney at law being present, in fact, we think they should be present for the child's decision whether or not to accept the care plan, the specialist expertise of a social worker would be beneficial. Those are the main recommendations that we have in relation to the Act, but there are two additional points of concern which we believe that the attention of this Honorable Joint Select Committee should be brought to. The first issue has to deal with children exhibiting behavioral challenges, formerly known as children who are deemed to be beyond control, as dealt with under the old Section 24 of the Child Care and Protection Act, which has now been amended, and we recognize that these are children who are to be described as exhibiting behavioral challenges. What we have observed in the field is that there is a reliance on the child diversion program regime to address matters involving children who are deemed to have a behavioral challenge. And we submit that this represents a misalignment with the intended focus of the principles which undergird child diversion. Child diversion is meant to deal with children who have actually committed a criminal offense, not children who are running away or who are sculling school. Therefore, to overextend the program by having it treat with matters that require a social and therapeutic intervention under the rubric of care and protection does not stay true to the objectives of the Child Diversion Act and the mandates of the Child Diversion Office. Neither is this practice in conformity with the internationally accepted principles of child diversion. Children with behavioral issues are not in conflict with the law and therefore require a different response, such as the therapeutic care orders that have been provided for in the amendments to the Child Care and Protection Act. These therapeutic facilities, which I understand are not operational at this time, despite the passage of the Act, need to become operational and equipped with the necessary human and physical resources as a matter of urgency. To continue to operate without them exposes Jamaica to continued negative international scrutiny and entrenches a practice that represents a disservice to our children and really ties the hands of the court when they're faced with dealing with children who do have behavioral challenges and need a residential therapeutic facility, for instance. Preliminary data that the Office of the Children's Advocate was able to obtain for financial year 2025-2026 is illustrative of the scope of the reliance and the misalignment that is being perpetuated. And the data reveals, for example, when we look at St. James, there were a total of 200 child diversion referrals, and 88 of them, that's 44%, was in relation to uncontrollable children. Clarendon as well, 39 referrals, 10 of them, that's 25.6%, were for children with behavioral challenges. St. Catherine had 99 referrals, 28 of them, which is 28.3%, were for children with behavioral issues. In Manchester, 85 referrals, 30 of them were for behavioral challenges, so that's 35.3%. Kingston and St. Andrew, 58 referrals, 7 for behavioral challenges, that's a 12% proportion. And in Westmoreland, 62 referrals, 34 of which, that's 54.8%, were for children who were deemed to have behavioral challenges. So our concern is that the use of the Child Diversion Office and its resources are being dedicated to a cohort of children that ought properly not to be benefiting from child diversion, because child diversion is for offenders. And if it is that you are having behavioral issues because of some post-traumatic stress or some other fundamental issue, perhaps a mental health issue, that is not for child diversion.
Just a clarification. Let us say this table you have given us, the total referrals and the number of uncontrollable. Are you saying out of the total referrals, these numbers, the 44 or 12%, were persons who were referred because they were uncontrollable?
Yes,
So
Chair.
even though they did not commit any offense?
Yes, Chair.
I didn't even know that. Yeah, right. So
that
a number
is
of
a
them
concern.
have been referred.
Yes.
But to the best of my knowledge, many or most of them went through the program successfully.
Yes, and that's what we're saying. So the resources are being used for children who really shouldn't be there in the first place. And so that is an overstretching of the program. It is a bastardization of the program as well, because it's being used for a purpose that it was not created to be used for, and it's taking away the resources from children who are in conflict with the law and really should be diverted.
I think most people would argue that maybe you should expand the program more rather than to reduce it.
No, I agree that the program is doing well, Minister.
Yes.
But my position is we have to contextualize things. And if there are therapeutic care orders that the court is empowered to make, but no place to send those children because the therapeutic centers are not operational, we need to fix that problem, because that is a deficit. And it means that the therapeutic centers that should be taking care of its own children are foisting those children on the child diversion program.
Come a little closer to the mic, I think.
Sorry, Minister. Yes. So I was saying that it's not that we're saying that child diversion can't fix it, but it's not a silver bullet. And if it is that you have child diversion focusing on matters that don't properly belong there, it means that you are inadvertently taking away the resources from children who properly deserve to be there.
But to the best of my knowledge, those who are deserving under the Act
Yes.
to be referred, they're not being deprived. They're still being...
Yes.
That is why I know there's a burden. That's why we have expanded the number of child diversion officers. In fact, in most parishes now you have at least 2. And the demand is there for a 3rd.
Accepted, Minister, but you can imagine if, let us say, this Joint Select Committee, and I hope it does, accepts the submission being made here today, that for minor offenses, that there's no identifiable victim and so on, the police are now going to start referring a lot more. And if the committee accepts the submission by the DPP, that the prosecution will also now be referring without necessarily placing the matter before the court. And you have a number of child offenders who need the services. Is it fair for the services to be split with children who are to be serviced, but by therapeutic centers? And so you are diverting, for want of a better word, the resources of the child diversion office to a cohort that doesn't properly belong there.
To be fair, the child diversion officers are not necessarily the ones who engage on a regular basis with the children. They're actually referred to mentors. So the mentors have been trained. And many of these mentors, as I will tell you, are JPs, Justice of the Peace, who we encourage to become mentors, but there are non-JPs who are also mentors. So, in all sincerity, I mean, what you're suggesting is that those who are uncontrollable, who have not committed any offense, should be dealt with differently.
Should be dealt with by the therapeutic centers that the Child Care and Protection Act say exist.
But
for
how were they referred? I don't understand.
The challenge, Minister, is that where the court perhaps finds its hands tied, they don't want to send the child to a correctional facility. They can't send the child home because the parents aren't coping, and the child really needs therapeutic intervention. But when there's an attempt to make a referral under the Child Care and Protection Act to that therapeutic center, there is none.
What I can't understand, though, maybe the Child Diversion Committee can help me. If they had committed no offense, why were they before the court?
Because there's still an opportunity, Minister, where a parent says, I can't manage.
Oh, I can't manage.
And they put the child before the court. And then the court is trying different ways of treating with the situation, but then gets to a point where I can't send home because mom isn't coping, there's no grandmother to support.
I see what you mean.
And so on. Then it's, what
Minister
do you do?
Dalrymple, for you.
Yes, Minister, I want to confirm exactly what Mrs. Gordon-Harrison is saying, and it is true. And really what she's saying is that we need to provide a facility for those children. And there are a lot of them all around the country. And it is true that the courts are sending them to the homes, and they are not equipped. So very often they go in there like that, and they come out back the same way because they have not had the benefit of the therapeutic treatments.
Before we,
very correct.
Can you finish up? You still have one small section.
Yes, I have one small thing, as well as another aside and concern, and this has to do with the placement of children now in correctional facilities. Some cases have revealed an uncomfortable practice where children eligible for diversion lack appropriate residential placement due to issues at their home within their communities, and they are then placed in correctional facilities while they undergo diversion. This is inconsistent with the purpose of the Child Diversion Act we're submitting and the general principles of juvenile justice, which maintain that deprivation of liberty ought to be used as a last resort. Children need to benefit from diversion in a supportive, non-custodial environment, and the Office of the Children's Advocate takes this opportunity to highlight this undesirable practice within the confines of this review for the Joint Select Committee's attention.
I want to thank you very much, Children's Advocate. And I know Senator Golden Campbell would like to come in, but just respond quickly to one concern I have. So those who have not committed an offense and they need therapeutic assistance, the first point. And the second point you raised towards the end is those children who should not be sent to institutions because of the problem at home. What would be your suggestion for those two?
To create the therapeutic centers that have been provided for under the Child Care and Protection Act, employ staff who are suitably qualified to work in those therapeutic centers.
So those no longer exist?
Well, as far as I know, Minister, I've been told that they've never existed.
Minister, those centers have never existed. Those children have ended up in children's homes for generations, and I say so from personal knowledge of the situation all over, and that is an area that needs to be addressed. And I just want, as I speak now, I want to congratulate the Office of the Children's Advocate, because what she has presented is exactly what is happening outside on the ground.
So to the best of your knowledge, Mrs. Gordon Harrison, no therapeutic center or child care, not penal institution, which is where you say they're normally sent, but are there any parishes that has any of these homes that these were therapeutic centers?
I want to make a distinction, Mr. Chair. So there are children's homes, there are places of safety, and there are correctional facilities. However, Jamaica has moved beyond children's homes, which really has a house mother, a cook, so on, beds, to say that we recognize that where children have behavioral challenges that really push the envelope, they can't be just in a home with a house mother who is beyond her wits. They require a specialized therapeutic care order. And our legislation under the CCPA has been amended to recognize this truth. What has happened, however, is that the amendment has gone through, but the functionality to make that amendment effective has not kept pace.
Okay.
So we don't have the therapeutic centers. So I'm using this opportunity to say that those therapeutic centers have to come on board as a matter of urgency.
And that is under the Ministry of Education?
Yes, Minister.
Okay. Thank you. Senator Shireen Golden Campbell, you'd like to come on now?
Yes, thank you, Chairman. I have two questions, and let me just start with this last point. that the children's advocate raised, I am still not clear in my mind what circumstances give rise to these children who are children with behavioral challenges coming before a judge. If there is no offense, what's the process by which they are entertained by a judge? That's my first question, and
Right.
I will let the children's advocate answer that.
If you don't mind, the law reform would like to just respond quickly.
Good afternoon, everyone. Right. I just wanted to point out that the amendments that were done in 2022, I believe, the end 2023, an appointed day notice has not been done, and as such, an appointed day notice. So the amendments were made, but the appointed day notice has not been done, and as such, the amendments that were to have happened have not happened yet. So Section 24, the uncontrollable child, still exists in our legislation, and so that is how the children end up before the court. They are still being placed before the court under Section 24 of the Child Care and Protection Act as uncontrollable because the amendments have not taken place, because an appointed day notice has not occurred. I believe it, and I can't give a reason why, but I may assume it's because they are trying to get the therapeutic centers, in place in order to effectualize this amendment. So that's the problem.
Okay, thank you. Go ahead.
That answers my question. Thank you very much.
Mm-hmm.
Chairman, I want to make the point just on the back of that before I ask my second question too. And it has come up in the committee before, the distinction between children in conflict with the law and children in need of care and protection. And I think it's something that we need to affirm, reaffirm, and repeat each meeting, because there's a tendency, when systems work well, as the child diversion system has been doing well, there's a tendency to ask that system to do work beyond its scope, as opposed to address the issue that is required to be addressed by the mechanism most appropriate for it. So we have to be careful, because the distinction between the two types of children, require different interventional approaches. So I just want to reiterate that point.
Nothing
My
succeeds.
second question.
Nothing succeeds like success.
Pardon?
I said nothing succeeds like success. This is why we refer everything to them.
And we tend to do this,
Yes.
So I think we have to be very deliberate about looking at the remedies that are required to be put in place for our children in need of care and protection. And I am grateful for the intervention of the Law Reform Unit in relation to the amendments. I didn't actually know that. My second question to the children's advocate is in relation to the insertion of a counselor in the process where the child victim is looking at whether or not they agree or consent to the diversion of the child offender. And I wanted to ask her, what happens in a situation where the counselor is present with the child victim and reaches a position that there is minimal impact on the victim? How does that square with the child victim's position if it were such that the child victim does not agree with the accused child being diverted, or the parent and the child don't agree? How do we deal with that situation, and what weight is placed on the child victim's consent to the diversion of the child offender in practice?
Okay, thank you. So the legislation currently treats with it, Senator, and it says, and I'm paraphrasing here because I'm not looking at the exact section, that even if the child doesn't agree, that's the child victim, the matter can still be diverted. So my understanding is that all of the different views would be put on the table. There would be a discussion as to what is the most reasonable course in all the circumstances. But the legislation as currently drafted treats with that.
Thank you very much.
Member Buchanan.
Thank you, Chairman. Your recommendation 2, which made mention of having the police, the mandatory referral mechanism. Now, in practice, because we generally, as in judges, the court generally wants children not to interface with the court. And I'm just asking, the system currently in place is for peddling, wipes, noise, disorderly conduct, street littering. These are matters that are convictions which are not recorded. These are also convictions where judges basically admonish and discharge sometime, even if they pay the fine, $2,000 or $4,000. In so as to not have the child not returning and missing school, and sometimes the best way is to dispose. So although the child is pleading guilty, it's so that they don't ever have to come back tomorrow, and it's not something that's trailing them. Do you still think that in relation to the minor offenses that and you raise about resource, we're talking about state resources and the best use of the diversion program, if making this mandatory referral mechanism is helpful? I just want you to consider that, because currently judges in their wisdoms wouldn't want to use child diversion, so to have the police now increasing diversion and finding mentors to say don't curse bad words. I'm just wondering if you're hard pressed on this one.
Right. Also, as well, so these are just 3 of the offenses I just picked out of the first schedule, but there are other ones. For example, possession of an offensive weapon, which
$4,000 fine.
Right, but often what we find is that they can end up in a correctional facility. So there is a case, for example, which I can share with you outside of the chamber, where we had the child who was arrested, charged, placed before the court, and sentenced by the court on a correctional order to, I think, was it 2 years? 2 years for possession of an offensive weapon in circumstances where there was no altercation. So we're just very concerned that while these are 3 examples, the full scope of the first schedule there with those offenses, we're saying if appropriate, instead of exercise, because then when you place it before a tribunal, there's really no certainty. So whereas there is a predisposition towards the court dealing with it in a particular way, there is no uniformity sometimes. And we certainly in our experience see where children sometimes do not benefit from the magnanimity of the court. And the impact is quite great.
I see where you just strengthened the Madam DPP's argument that she should have the power to refer to protect the children from the heavy hand.
Yes.
My recommendation 3, you said it says that a record may be kept if the police is so determined.
No, may I just add to that? You finished?
No, I would like to see if she's hard, if Ms. Gordon is hard pressed on this, because I'm putting on record that I'm just objecting to any record keeping.
No, not a record to say this child is warned, It's just a little note in his notebook or his pocket, so that if he sees John Brown next month again, probably in school, he can say, I warned you already,
But what I would like to add, though, Member Buchanan and the Children's Advocate, it seemed to me, though, that if there could be different levels of, delinquency. So if it's just a caution and say, don't do it again, then the choice whether to record or not in the police diary could be discretionary.
But it's not even in the diary. This is,
No. But I think if the child is being put on a recommended for a child diversion program, it should be recorded, so that if the child completes the program properly, at least it is there to show that the program has been completed.
Yes, I agree with you, Chair, and that's not what my concern was. So if it is that the child is cautioned and referred to the program, of course, there has to be a record. If it is that there is a formal warning that's done at the police station in the presence of the parents and a referral is made, there has to be a recording.
Right.
If it's an informal warning now, which can happen on the spur of the moment,
Sure.
the child is seen doing something at the transportation center, and the officer says, "Why are you doing that? You shouldn't be doing that." There is no requirement at this stage for that to be formally recorded, and we're fine with that. What we're saying, though, is that the police were saying sometimes they want to just have a little reminder, so that if they see little Delroy sculling school Monday, and then somebody else sees him on Tuesday, they can probably go and speak to little Delroy's mother to say, you know, that this is happening, right? So, from that perspective.
You know, Chair, if I may, that was where my discomfort is, because I don't want it to be a profile being built on little Delroy. Because then little Delroy may not end up being big Delroy, because they started to say that he was in the transport center, then he cursed a bad word here, and he's still in the juvenile stage, and the best interest of the child is not to be profiling the juvenile so much so that other officers can say that another officer interfaced with this young man and he's just a troublemaker.
Minister Dalrymple, you wanted to add?
Well, I take a different view. Because what I understood the children's advocate to be saying is that you might have an exercise book which might help that particular child. You see him here today, you talk to him today, and you buck him up all the time, but you don't always remember a child that you see. If you look in the book and you see it, you remember now that this is a child that needs some help. I didn't understand it to mean that it is a child that you're taking from. It's just a child now that even some of the officers in your district and area, and you can go and talk to the mother who is not aware and say, look, I see child A here 3-4 times this week in a particular place. Check on whether they're going to school or not, what they're doing there.
Yes.
And I understand from a police officer's point of view, all of us, I started making notes of what you're saying here. You make a little note just so that you can jog your memory to know exactly what you're dealing with in the community.
Yes. That was exactly the consideration, member. In fact, there was very heavy push from the Community Safety and Security Branch to say, look, they have actually started to even father some of these children who come up. So if they see, consistently in the transportation center and the child says, well, it's because I don't have any lunch money or I don't have any school shoes, they will rally their squaddies to see if they can buy those school shoes and keep checking in with the child. So it wasn't from a punitive perspective. It was more from the perspective that says the community needs to rally to assist because there clearly is an issue here.
Let me ask you just directly. You would support most of the recommendations from the DPP. In other words, they can do referrals directly.
Yes. The only time I had a little concern, Mr. Chair, and thank goodness the DPP satisfactorily addressed it, because I noted it, was when there was some discussion that for parish court matters, simple larceny and so on, that the clerk would now have to await the DPP's response to determine whether or not to refer, because, as DPP says, the clerks are trained attorneys, and then also that would lead to a delay of another sort and a bottleneck which we'd not like to encourage. So I do agree with certainly the discretion of the DPP to refer without the matter being placed before the court. The only issue that I would say we fundamentally are not on all fours on is the exclusion of Section 9A, which speaks about acceptance of responsibility.
I think your suggestion, though, that we make it very clear that accepting responsibility doesn't mean pleading guilty, which is exactly what both Senator Golden Campbell and the DPP are saying. Because that is where the Chief Justice has said that their interpretation is different from what we are seeing in the legislation. So we must just make it very clear that accepting responsibility doesn't mean pleading guilty.
Yes.
Because as we have seen, pleading guilty creates a lot of problems. Any other questions? Children's Advocate and DPP, I wanted you. I'm not sending your way. We have 3 other presentations, but we don't want it to be felt that we want it to be remain. But I know DPP, you had indicated that you may have to leave early. But your team can remain, and anyone who wants to remain while we go to the coalition. Oh, before you go, DPP, Mr. Green, can you, if you don't mind, give us a document outlining everything you've said? You'll be in touch with Mr. Nash and send a copy for me, please, okay? Because we're going to do a final report to Parliament, and we wouldn't mind putting all the presentation as an appendix to the report to Parliament, okay? So just assess it, and you might want to do any, and same with Children's Advocate. Well, yours is comprehensive, but if you want to do any adjustment, we want to just attach it as the appendix to our report to Parliament. Mm-hmm. So we're going. Sorry.
Chairman, just to say the DPP's presentation was sent to us. The PowerPoint presentation is pretty succinct and clear.
But if you want to adjust it in light of your additional matters that you brought in, you could just do an addendums to it. Okay. Thanks again.
Including Chairman, including that response in relation to the criteria on the 9.2.
Right. The Jamaica Coalition for Health and Society. I think Dr. West, you're here. Could you please say who is with you, and then you can proceed, Dr. West.
Can you hear me? All protocol observed. And with me today, to my right, is Ms. Philippa Davis. She's an attorney at law. And to my left is Dr. Kay Bailey, who is a pediatrician. We have Ms. Angela Templer, who is in the gallery upstairs. I just wanted to apologize on behalf of Mrs. Shirley Richards, who is the chair of our legal committee. She was to be here last week, but because of the change in date, she cannot be here. Just to make 2 quick observations. One, our commitment is to diversion. It's our preferred option and objective. The other consideration is that the child, we agree entirely with the consideration that the child should not have to plead guilty, because that we think undermines the whole process. Ms. Philippa Davis will be doing our substantial presentation, so I will turn over to her now. Thank you.
Go ahead.
Thank you very much, Dr. West. Good afternoon, Chairman, honorable members, other presenters. I will, if you permit me, make the presentation and then be happy to receive your questions or comments. Mm-hmm. The Jamaica Coalition for a Healthy Society commends the implementation and operation of the Child Diversion Act. We urge the government to fully resource the program so that it can become even more effective. The real concern is that there are still too many children who come into conflict with the law and who, for one reason or another, end up either in the program or before the courts. I pick up on a question raised by counsel from the DPP. Why does a child need to be in the program? This committee will want to step back and ask itself, how can we reduce incidents of minors coming into conflict with the law? Is there anything which can be done to reduce these incidents? The JCHS certainly believes so. The Child Diversion Act states that the best interest of the child is to be of paramount consideration in the design and execution of the diversion program. We will share data and recommendations which we believe are in the best interest of the child, focusing on factors highlighted in Section 2, subsection 2B, that concern the physical, mental, and emotional needs and level of development of the child. The first point is the home environment and social activities of children. Jamaican child development specialist, Professor Maureen Sams-Vaughan, has written that, quote, supervised activities, reading and attending church were associated with improved academic performance and behavior. Excessive television viewing of more than 20 hours per week at 12 years was associated with, impaired cognitive function, academic performance, and behavioral problems, end of quote. We could probably substitute television viewing with social media use by adolescents for similar effects. Dr. Sams Vaughan's study also stated that Jamaican children who live in the less emotionally stable common law and visiting unions, and those in single-parent homes or homes with a biological and surrogate parent, had more problem behaviors and lower cognitive and academic achievement. Though its effects on children's outcomes were not as strong or as global in impact, limited parental participation in children's activities also impacted negatively on cognitive, academic, and behavioral outcomes, end of quote. Interestingly, the Heritage Foundation in the USA, having studied the issue, has concluded inter alia that a mother's strong, affectionate attachment to her child is a child's best buffer against a life of crime. And the father's authority and involvement in raising his children is also a great buffer against a life of crime. A statement issued recently by a local group of church leaders urged that stronger homes must become a national priority, as must marriage. This is a call we heartily support. From the UK Relationship Foundation, an NGO, estimated the cost of UK family breakdown at £51 billion in 2018, costing each taxpayer around £1,820 a year. And this represents an estimated 3% of the UK's GDP. That's the cost of family breakdown in the UK, which is greater than what the UK government spends on national defense. The JCHS believes that any government should make intact family life a national priority, and all laws and policies should be scrutinized carefully in an effort to assess potential impact on the family. Our second point is on the evidence-based approach to addressing sexual intercourse between minors under the age of 16 years. We have noted a strong push that's being made for the decriminalization of so-called consensual sexual intercourse between minors under 16 years of age, with the recommendation that there be close-in-age exemptions. We strongly object to this suggestion and to the notion that minors can consent to sex, whether with each other or with adults. We also disagree with the suggestion that adolescent sex is to be deemed as normal, mere exploration, and unharmful. This is so far from the truth. Sex is more than a physical act. It carries long-term psychological consequences. And that's because the largest sex organ is not what's down there, it's what's up here. The largest and most important sex organ is the brain, because of what the brain does, the chemicals it releases during sexual activity, and the powerful effect of those chemicals on choices and resulting behavior in individuals, regardless of age, but with even more potent effect on children. What I'll be sharing is drawn from this book, Hooked, New Science on How Casual Sex is Affecting Our Children, written by Drs. Joe McElhaney and Frida McKissick-Bush. It is easy to read, full of critical research and empirical data, and I highly recommend, in fact, I urge parents, educators, child development specialists, and you, legislators, to read. So how does sex hook children? Well, actually, how does sexual activity, which is broader in scope, hook? That's the intentional, sexually intimate behavior between two individuals, or one, if self-stimulated. We're talking about sexual intercourse, but also anal penetration, oral sex, masturbation, showering together, fondling of breasts, petting, hugging, behavior that is sexually stimulating. The brain releases several neurochemicals during sexual activity, of which I will mention three important ones: dopamine, vasopressin, and oxytocin. Dopamine makes a person feel good when he or she does something that is exciting, exhilarating, or rewarding. Speeding down the highway, eating chocolate, if you like chocolate, getting good grades in school, sexual stimulation. Dopamine produces the desire to repeat pleasurable, exciting, and rewarding acts. Oxytocin, primarily active in women, is released during childbirth and breastfeeding, but also during intimate touching and sexual activity. It produces a bond to trust the sexual partner. Vasopressin, also called the monogamy molecule, is primarily present in men, and it produces bonding and the desire to protect the sexual partner. Now, these chemicals, when released, are values neutral, meaning they're not assessing whether you should or shouldn't be engaging in sexual activity, or whether it's the right person or the right time in life or not. The chemicals are responding to stimuli. They're released in both healthy and unhealthy situations. So dopamine is released during consensual sex between a husband and wife, or sexual activity between a teen boy and a 30-year-old woman, or transactional sex between a prostitute and client, or a female victim experiencing rape. In the case of trauma, it is not indication of pleasure at being assaulted, but it is reflective of the involuntary neurochemical response to the stimuli. The pleasure reward chemical therefore makes sex addictive. That's great for husband and wife in marriage, but disastrous for teens engaging in sex. The vasopressin and oxytocin release bonds husband and wife to strengthen commitment to their relationship and each other. But a 14-year-old girl should not be sexually bonding and trusting a 30-year-old man. What happens if partners break up and move on to another? Of course, there are implications. The dopamine addiction drives speedy entry into a subsequent sexual relationship. And the neurochemical imprint of that sexual relationship remains on the brain long after the end of the relationship. With each bond and breakup, there is decreased ability to connect with future partners. There is less ability to trust and less motivation to protect. Imagine these two pieces of paper, the male and female sexual partner, bonded like glue through sexual encounter. What happens to that brain bonding capacity if the sexual bonding is pulled apart? Not a good consequence if you want a meaningful, long-lasting future relationship. The implications of early sexual encounters is not just the risk of an STI, an STD, or early pregnancy, but also the emotional damage of depression, shame, guilt, regret, distraction from schoolwork, jealousy, and even violence when one partner moves on to another. Now you may wonder, how does one manage or filter sexual stimulation? That is the role of another part of the brain, the prefrontal cortex, right here. The prefrontal cortex is called the executive decision part of the brain. It's responsible for long-term planning, setting priorities, impulse control, and complex decision-making. Now here's the thing, our brains mature from back to front. So the prefrontal cortex, that executive decision part of the brain, is the last part of the brain to mature. Can you imagine at what age our brains mature? Between 25 and 30 years of age. In the immaturity of the brain development, it's not their fault by design, children and adolescents are more impulse-driven, acting first, thinking after, maybe. Studies have shown that the teens have less white matter, the myelin, and the myelin is necessary for better information flow between the brain regions. As they go through adolescence, the white matter increases. But now we're not saying that the immature development of the prefrontal cortex means that children are stupid. No, they can be quite bright, doing well in school, but the reality is that structurally, their brains are not yet fully prepared to handle the complexity of some very adult circumstances and decision-making. So with an immature prefrontal cortex, Even if adolescents understand that something is dangerous, they may still engage in risky behavior. Honorable members and other presenters, we know this. We've all been around and observed teens and tweens and their impressionable, even illogical, impulsive conduct. And the Children's Advocate has also spoken about the vulnerable period of adolescence. That is why children and teenagers need wise, protective adults around them to protect them from the risks of their structural immaturity, to protect them from unwise decisions that will have lifelong consequences. It is not for adults to concede to those risky behaviors, to excuse it, or to normalize it. Let me add that the neurochemicals are also released with self-stimulation through the consumption of visual images on a screen, such as pornography. The pleasure hook is no less because there's no in-person physical touch. In fact, the dopamine hit to the brain is even more potent, like crack cocaine. This is an excessive high with a massive low, a stronger craving for more graphic stimuli to get the same level of dopamine pleasure. Pornography is lethal and dangerously addictive. The Reproductive Health Survey of Jamaica 2021 final report, prepared by the National Family Planning Board and the Statistical Institute of Jamaica, stated that, one second please. Thank you. Young females and males who have sex earlier report higher incidences of unprotected sex, unintended and unwanted pregnancies, multiple sex partners, and higher rates of STI and HIV transmission. The report also said that more than half of young males, 57.8%, and 22.7% of young females had their first sexual encounter before the age of consent. And 46.7% of young females and 19.7% of young males were coerced into having sex at their first sexual encounter. The report also states that any sexual activity that occurs when an individual is pressured, tricked, threatened, or forced non-physically is classified as sexual coercion. This data challenges any presumption that adolescent boyfriend or girlfriend sexual encounters are consensual. But there is good news, Mr. Chairman. Our brains have plasticity, meaning that they are moldable and adaptable. Neglect, poor guidance, lack of discipline molds a child's brain towards negative outcomes. However, structure, discipline, and encouragement of healthy behaviors are positive molding effects. The consequences of unhealthy choices are real, but new and better neural pathways can be formed through healthier choices and better patterns of behavior. It doesn't happen overnight, but the ability to form long-lasting, committed sexual relationships can be redeemed. The mind can be renewed, the brain's capacity can be reset through healthier choices and behavior. Also, attentive and committed fathering and mothering are critical protective factors to mold our children towards healthy behavioral choices. The 2007 Jamaica Youth and Risk Resilience Survey reported that frequency of church attendance was associated with sexual experience, being much higher among those who never attend church, from 17.8%, among those who attend church more than once a week, to 31.7% of those who never attend church. This piece of vital information should be utilized by the diversion committees in every parish. But helping our children to avoid sexual activity is not a matter for the church only, as it affects all of society in one way or another. Therefore, the state should not be reticent about publishing this message using all the available social media platforms. So our recommendations: 1, to teach our children, teens, and adults about the neuroscience of sex. All sexual activity must be understood to have profound consequences on the emotional and psychological nature of the individual, whether a minor or adult.
The information that we share today from the book Hooked can be easily condensed into a child-accessible format for teaching children who have been referred for diversion, or even in the school curricula. It would be a critical element of educating a child's healthy mental and emotional development, understanding choices and consequences. 2, concepts such as safe sex need to be reviewed, considering the long-term neurological impact of sexual activity, not just intercourse. Condoms and pills cannot protect brains and hearts. 3, utilize all various media platforms to publicize the value of abstinence and the adverse consequences of early sexual activities. This is not just about values and morals. This is empirically based responses to real-life national social challenges. 4, preventative long-term measures to reduce the incidence of youngsters coming into conflict with the law include remedying our dysfunctional family life. This involves prioritizing and rewarding healthy family life. Encourage parents to have their children within the marital union. This will give the child the benefit of father and mother in the home. The value of marriage must be taught and modeled to our young people. Develop curricula to teach effective teaching of parenting in schools. Continue to encourage and teach parents how to positively shape their children's lives. Sustain the parental support system, such as the Parenting Support Commission. Encourage young people to go to church and get involved with supervised activities. 5, keep the law as it is regarding sexual intercourse between minors. No close in age exceptions. The law is a teacher. The law is a teacher, and it currently provides safe space for both boys and girls. Close in age exceptions will not reduce early sexual initiation. It will not prevent or lessen the mental, emotional, physical impact of minor on minor sexual encounters. Close in age exception will have the effect of normalizing unhealthy and unwise choices and sanctioning lifelong harmful outcomes for our children. And 6, reports on the child diversion program should be tabled in Parliament at least once every 3 years. And from such reports, Parliament will be able to ascertain whether amendments to the legislation are necessary. We are grateful for this opportunity to present to the Honourable Committee, and we thank you for your attention.
I want to thank you very much, Ms. Philippa Davies and your team for putting this submission together. But while personally I agree with everything you have said, most of it is really not for the child diversion jurisdiction. For instance, I don't think the persons in child diversion could undertake 90% of what is recommended. They are good suggestions. I personally will promote them. Good parenting, children within marriage, and so on. But with due respect, the Child Diversion Committee or the members of the Child Diversion Committee, I couldn't direct them to go out and preach good parenting, for example, or that children must go to church. You have heard of Emil Durkheim, no doubt the sociologist. And he believes in the different social units, the division of social responsibility. So certainly, the church, the schools, the community, and so on have responsibility to do this thing. But the law cannot be used to teach good parenting, for example. In other words, if the law basically said, don't do this, the law rarely says, do this. Because it says, don't do this, and if you do it, there's a sanction. The moral law, which is most of what you have suggested, which are really commendable, suggests do this for a better life. But the law never tells you what to do to become happy or to become great or prosperous. What the law does is to tell you what not to do. Because if you do it, a penalty follows. So I really would like to suggests that a lot of what you're promoting should be promoted in the schools, in the community, in the church, because these are commendable. But to say that the child diversion or the state must, or the law, use the law to promote them would be extremely difficult. In other words, the law couldn't say, you must be happy, and if you're not happy, we're going to punish you. You see, so I'm just trying to show you the distinction between the moral law and, legal system. Just to ask you one question, though. You have been here all morning, and look at the closing age, which is being recommended by many groups, because if a person is actually convicted when they're a teenager for consensual sex, it follows them for the rest of their lives, to be frank with you, because they're not expungible generally. So there are many, many farm workers now who are asking for expungement when they were 16 and they pleaded guilty to consensual sex, because that is. And that is why many parties in the country have said we must not criminalize such activity participated in by children, because of the long-term, almost career-defining moment. I just want to ask you, assuming we decide not to remove or not to put in place that law of closing age sex, would you agree that the Director of Public Prosecution, when it comes before him or her, that if it is a consensual sex, that they could refer it to child diversion without it coming to court?
Right, thank you for your comments, Chairman. And yes, we appreciate that what we have shared may not fall directly with the remit of this committee, but we have shared information that we believe is important to the holistic work and purpose of the child diversion program. And as I had suggested, one is to perhaps include in the programs, whether it's through a counselor or teacher or otherwise, this information that I shared from Hooked, as we believe that is very important for young persons to understand that it's not mere emotions or feelings, but that there are long-term implications to current and future relationships, which is why they need to exercise wisdom and caution in terms of sexual choices and behavior. And then that leads me to answer your question, that if the law says that you cannot consent to sex at age 16, how can you accept legally consensual sex between minors? And this is the challenge that we would face, why we would not agree to a closing age exemption.
No, but assuming it is there, and it comes before the DPP, and all the evidence suggests that it was consensual sex. We're talking between youngsters, or close in age. Would you agree, or what's your position? Should the DPP exercise his or her discretion to send it to child diversion, and if the parties complete the program satisfactorily,
yes,
then no charge?
Yes, Chairman, we would agree for them to be sent to child diversion, but it doesn't change the law.
But you'd like the law remain and allow the discretion of the DPP to go to child diversion? Okay. All right. Minister Dalrymple.
I wanted to.
May I just add one thing, Mr. Chairman?
Sure, go ahead.
Yeah, again, we are here for diversion. That's what we are here for. And secondly, we are also here for the children not pleading of the same near age thing. In any situation where it does not plead guilty, because in a sense that defeats the purpose of the Diversion Act, as I think the child advocate said. We take your points about the thing of the law, but Dr. Bailey and myself are medical doctors, and prevention is always better than cure. And whilst we appreciate that the law is dealing with treatment, prevention is better than cure, and we thought we'd be remiss if we didn't highlight preventative measures. Okay. That's one. And also that those preventative measures could be incorporated in what the people who are mentors in the diversion program are doing. So that is why we took that particular perspective.
Okay, thanks, Dr. West. Minister Dalrymple.
Thank you very much. I wanted to thank you for a good report, like the other reports that come to us. And Dr. West has cleared up the point why I quickly put up my hand, because I do agree, and I think presently that the officers in the child diversion program are, in fact, encouraging young people not to go the way. But you have to understand that today, in today's society, there are many fabulous mothers, fathers, uncles, aunts that had a wild beginning. So it is, you know, they're young and all sorts of things they did. And they have matured, they have come a far way. Now, it comes back to the whole point of criminalizing sex between young minors. Let me tell you, there would be a lot of adults now in church, in this society, in high positions, fabulous parents. If we couldn't erase those records, that would have a criminal record. Because what we are saying, and you're correct, we need to teach children all the good values. But I hold strongly to the fact that it happened to people who are excellent adults and leaders in society now that made mistakes as young people, sex underage, between minors. What do you say? We are saying at this point, when it happens, there must be a way not to criminalize them, help them through the child diversion program, and more so, remember, there's a saying that says, doctors differ, patients die. The courts say if we want the judges to interpret something, we must put the law straight so that they interpret it straight. So you get before some courts, and a court might say, this person goes here, this one has a record, this one doesn't have a record. What do you do with two innocent people that fall into that gap, that years gone by and they have a criminal record? That is where I have a difficulty.
Again, our position is absolutely clear. Diversion, no guilty plea. I don't know if we can make that any clearer. So we are not saying that if persons are caught in sexual activity and they are near age, that they should be criminalized. We say we keep the law as is, because the law is a teacher. And we don't want the law to be used to teach something else. But at the moment, we are able, even though the law is the way it is, to divert to, away from the court and to not have the person plead guilty. What we are adding, we're not denying that things do happen. But what we are saying is that the law is a teacher and there is a consequence to activity. So we don't want the law to teach people that there is no consequence to activity. We want people to understand that there is a consequence to activity. But we must seek to make sure that these young people are not criminalized. And that has been going on, so we don't see a need to change.
May I ask a question, Dr. West? Would you remove at this moment all of those persons who have been convicted for, they call it carnal abuse, which is real carnal abuse, where the evidence suggests that there was consensual sex, because they have pleaded guilty or they have been found guilty? No. We're talking about youngsters who came before the court and were charged and they pleaded guilty to consensual sex. At this moment, they're not expunged. Yes. Mm-hmm. Because many of them now can't go on farm work program
God is forgiving. That's the difference between God forgives. It's not something that I have thought about before, but as I said, the principle that we operate on is that we do not want children who for prefrontal cortex as far as possible to be criminalized. But we also do not want the law to be a bad teacher.
No, what I'm asking
so the
is...
question is, would I retroactively
What I'm asking you is different.
Would we retroactively pardon off the top of my head? Now, this is me speaking as Wayne West because we tend to consult within our group, okay? But I would think that if that is causing a problem for those persons, something that they did when their prefrontal cortex was immature and so on, then maybe there is a good grounds for the state to pardon them.
No. What I'm saying is, in the Expungement Act, we don't expunge, carnal abuse or sexual consensual intercourse between youngsters. So they have come to court, pleaded guilty, and so they have a record. And because they have a record, it is carrying over. And what I want to know is that we could put it in the third schedule of the Expungement Act to say that if the person had intercourse with a youngster and they were close in age and it was consensual, it is expungible. At the moment, it is not expungible.
I would think it should be. It would depend on the individual case. If this person is someone who has been shown to be an abuser and so on, then no, I wouldn't want to do that. But if it's a person who had maybe a one-off incident, off the top of my head, I don't see a reason why it should not be.
I'll give you a good example, Dr. West, which I've repeated here before, but I want to tell you, a case that brought tears to my eyes was this from, I won't say the parish, but it's a mother who wrote me a 6-page letter where she was, I think, I don't remember the age, 14 or 15, and a 17-year-old boy had intercourse with her, consensual sex. He pleaded guilty and got a probation order. When he completed the probation order, and soon after, she must have been 18, they got married. They have adult children who live overseas, work overseas. She can visit them, but he can't.
So, like I said, that should be expunged. I see no reason why it shouldn't be.
That's why I'm asking you.
And I agree. So I'm making the point.
Okay.
I'm saying that I see no good reason why something like that cannot be expunged.
So you support expungement of those?
Yes, but I don't support removing the law. That's a different thing.
Not in the act with us.
But you see, at the moment, it's not in the act, and we
there.
want to put it in the act.
Reverend
I
West,
think you should put it in.
Dr. West, the point is, it is not there, and I'm saying right now, there are several young people who do not have an opportunity to gain employment because of this. And I understand what you're saying, and I agree with the good teachings and the Christian things.
But we've said more than that. We said expunge the things so they get the opportunity.
We can't sit here and just put
we can
it
make
there.
a recommendation.
No, but I'm saying to get that there is going to take a long process of many years. What we're saying to you now as we are alive, that there are young people now who are good people, who have had this experience, who are tainted for life, will not have an opportunity. And I go back to my own Christian principles where I know that the Lord forgave.
All right. All right, we want to wrap up, so we're going to, because we have 2 short presentations afterwards. Senator Golden Campbell, you have an input, the last input to the... yes,
Thank
yes.
you, Chairman. Chairman, I just want to make some brief remarks. And I, in principle, don't take much issue with what the coalition has presented to us today. Where I think I depart and I think is an important distinction to make, is the question of what purpose does legislation serve? And I think you alluded to it, Chairman. I have a difficulty sometimes with how far the state goes when it is seeking to legislate matters that are really within the purview of families. And I appreciate the fact that, much of our familial system is in, for want of a better word, disarray. Some parents don't have the tools. Some parents themselves are children, and that presents a problem. I think the coalition has kind of raised an elephant in the room problem, and that is the breakdown of the family. I have for some time been ruminating on the need for a Ministry of Family Security and Welfare. I don't know if the Prime Minister is hearing me. But, I think we have to be careful about legislating matters that families really have to confront themselves. I think the role of government and the role of the state should be limited to providing support for families, not criminalizing them when they don't take what we deem to be appropriate action or teach appropriate morals. I think we're getting into murky water when we do that. And I understand where our religious perspectives may lead us in that regard. I grapple with it myself. So I just wanted to say that as a base point, that some of these things are not things that we can legislate, but I do think the state can do a lot more to support families so that they are strengthened, parents are strengthened to be able to deliver, guidance and moral direction to children.
Thank you.
I do want to ask.
Sorry. Go ahead, finish.
I do want to ask the question, however, and you seem to have elicited the response in relation to whether or not these children should, minors who are charged with having sex. And I want to ask the coalition, particularly in relation to the brief that I have in front of me. The study that has been cited, which speaks to the incidence of minors who are forced into sex or sexual encounters for their very first experience. And I want to point out that based on what I am reading, that question of coercion does not fall within that bracket of minors having quote-unquote consensual sex. Once coercion is introduced, we're talking about a different offense. We're talking about rape, or we're talking about grievous sexual assault. And I think it is not wise for us to conflate the two. We are, in relation to that Section 10 offense in the Sexual Offences Act, which is having sex with a person under the age of 16 years old, when that offense is committed by two people who are themselves under the age of 16 years old, and they do that voluntarily and intentionally, it is not the same thing as saying that one has been coerced. And I think we have to be careful about that, because the coercion cannot be, or ought not to be, ought not to be assumed by virtue of the fact that they're minors. It is determined on the basis of an investigation, interviewing the participants, police taking statements, and determining whether or not these two young people have come together intentionally and voluntarily, or they have done so with one being coerced by the other. So I just want to make that clear, because that's a big part of the gray area the murky waters in these discussions.
All right, thanks to Senator Sharon Gold. You have,
Yeah,
you want to respond to that?
Yes, I was just saying that we didn't conflate them at all. We just dealt with the issue of consensual quotation marks between, but because we know what we're dealing with, as I understand from the Diversion Acts, is young people actually committing offenses. And how do we deal with them when they commit offenses? Should we put them in the court or should we seek to divert? And we are saying divert, whatever, not only in this context of consensual sex, but as far as possible for whatever, if it is possible.
Thank you very much. Thank you very much, Dr. West. Thank you very much, the Coalition for Health Society. We have 2 presentations remaining, and I'm going to ask both presentations. I think Mr. Doan has begged to go first. So we're going to ask you to just summarize what you have provided in the script, Mr. Doan. And then after that, we ask Mr. Christian to also summarize his presentation. So go ahead, Mr. Doan.
Greetings, everyone. Are you hearing me? All right. So, Honorable Chairman, distinguished members of the Joint Select Parliamentary Committee, ladies and gentlemen, good afternoon. I stand before you not only as a representative of the foundation, the RDJR Foundation, but as a voice of many young people or many young Jamaicans whose futures depend on decisions made in this very room. Our objective is clear, to strengthen and modernize Jamaica's child diversion framework so that it promotes rehabilitation, reduces reoffending, and ensures that every young person is given a fair opportunity to reintegrate and contribute meaningfully to national development. This is not just policy work, it is nation building. This proposal reflects the lived realities, concerned and aspirations of Jamaican youth. It is grounded in 3 core pillars: youth empowerment, restorative justice, and nation building. The review of the Child Diversion Act 2018 presents a critical opportunity not just to fix gaps, but to build a system that truly protects, restores, and uplifts. Honorable members, why does diversion matter? Because children are still developing, and as what the other presenters said, these are young persons, they're developing still, their minds are still in the cortex of development process. Because one mistake should never define an entire life, because the justice system, if not carefully applied, can do more harm than good. Diversion reduces recidivism, it preserves human potential, and it builds safer, more stable communities. Let me be clear, diversion is not leniency, it is a strategic investment in Jamaica's future. However, despite the strong legislative intent of the Act, there are serious challenges. Early exposure to the formal justice system continues to stigmatize young people, it hardens attitude, and it deepens circle of poverty and crime. We also face gaps in implementation and critically limited youth involvement in shaping the very system designed to serve them. If we are serious about reform, these gaps must be addressed. One of our key recommendations is the institutionalization of youth voices. Young people must not only be recipients of policies, they must be partners in shaping it. We propose the establishment of a formal youth advisory panel connected directly to the Ministry of Justice or Parliament. This body would provide ongoing feedback, ensuring that diversion programs remain relevant, effective, and grounded in real experiences. I can tell you, as someone who has been through the system, diversion does more harm than good. This body would provide ongoing feedback, ensuring that the diversion programs remain relevant and effective. As I said, when youth perspectives are included, policies gain legitimacy, improve outcomes, and better reflect the realities on the ground. I am soon finished. Please bear with me. Secondly, we recommend expanding mentorship and national linkages. Diversion must not go beyond the intervention, it must lead to transformation. We must connect young people to national youth service initiatives, skills training initiatives, apprenticeships, and entrepreneurship experiences and programs, community volunteer network, structured mentorship is essential. When young people are guided by strong role models, they gain direction, discipline, and purpose. They begin to see themselves not as problems but as potential. And as young persons, many of us face this problem. When we go through the system, we feel like we are the problem. But what my recommendation is aiming to go through with is that they will begin to see themselves as not the problem but as potential. Thirdly, we emphasize civic education and leadership development. If we want responsible citizens, we must invest in civic understanding. Young people should be taught their rights and responsibilities, the principles of the Constitution, and, of course, their role in national development. Through community engagement projects, they can actively contribute while building leadership skills. This transforms perception, from exclusion to inclusion, from disengagement to ownership. Another critical area, and I think this is very important, is mental health and trauma-informed care. In Jamaica currently, there are not many facilities to house young persons who have behavioral disorders or even mental health illnesses. These facilities are not in Jamaica. If you need these facilities, you have to go overseas. So I recommend that these facilities be implemented within the Jamaica's framework and allow for young persons to be able to take from these programs or have access to these programs. No system can succeed without sustainable funding and accountability. We must ensure dedicated budget allocations, continuous training for diversion officers, clear and measurable outcomes. We should track reduction in reoffending, educational re-engagement, employment placements, successful reintegration into society. Transparency in these areas will build public trust and demonstrate that diversion is not just compassionate, it is effective. Finally, we must address dignity and stigma. A child who completes a diversion program should not carry a lifelong label. We recommend strong confidentiality protection, structured reintegration protocols, systems that support second chances, because second chances are only meaningful when they're supported by real opportunities. The Child Diversion Act 2018 was a progressive step forward, but legislation alone is not enough. We must now move from intention to impact, from policy to practice, from intervention to transformation. The recommendations presented today are not abstract ideas, they are practical, achievable steps towards a justice system that is fair, restorative, and future-focused system. A system that does not give up on youth, a system that recognizes that every young Jamaican, regardless of their mistakes, hold value and potential. In closing, I leave this with you. The strength of a nation is measured not by how it treats its best citizens, but how it restores those who falter. Let us choose restoration, let us choose opportunity, and let us choose Jamaica's future. I thank you.
Thank you very much, Mr. Don. I'm going to don't leave the question in until we hear the next presentation, and then the questions could be directed at either of you. So, Mr. Christian, you're ready?
Sure. Okay, I guess I'll go without my presentation.
Okay.
That's fine. So, thank you, Mr. Chairman, as well as members of the Joint Select Committee for, allowing me to share my recommendation. I will not, go on to praise the act like I have in my presentation, because I'm sure we all agree that this is a wonderful act that was introduced in Jamaica because we want to emphasize, rehabilitation and, of course, redemption for youth. So just by way of introduction, I'm an assistant professor of criminology and criminal justice at East Carolina University, which is in Greenville, North Carolina. I also serve as a child diversion mentor for the Kingston Parish. And so I am very much looking at this from the perspective of a researcher and also a member of the public who wants to, be more familiar with the data. And so my recommendation is that we establish a formal national evaluation and public reporting framework, one that involves annual public reporting, standardized national metrics, and independent evaluation, which could take place every 3 to 5 years. So the first component of the annual public reporting, I'd want to see where we're able to access numbers of referrals. So we'll have this by parishes. I know that Section 5 of the Act gives the power where, data is collected for statistical purposes, but how I understand it is that this is currently for internal use, and it is not so much where the public can benefit. So as a researcher, as other researchers, we would like to have this information where we can conduct research and we can have, we can make recommendation, from our research. But not only that, we want the public to be able to benefit when they see the numbers, because we may say that the program is doing well, that the child diversion, but if you want to buy support, sometimes people want the numbers. So I will commend, for example, the Jamaica Constabulary Force for its statistics section on their website, which is very much up to date. That's what I would love to see, because in speaking to the, someone at the child diversion branch last week, I understand that a lot of what they do is manual. So it's a hybrid system. There's some electronic data collection, but a lot of it is also manual. So we'd want to see referrals by parish. We want to be able to understand the different offense categories. We want to see completion rates and time to completion and so on. And then if there's any re-referral, right? So if there's recidivism, any sort of reoffending. The next component is the standardized metrics, right? So again, uniformed reporting categories, right? So we can compare the data, because of course we know that disparities will exist, especially when we look at rural parishes. So we want to be able to, see how, what sort of referrals are coming out of each parish, and have a better understanding of resource disparity. And then my third and final component is the independent evaluation. And again, in speaking to, I don't remember her title, but she's at the child diversion branch, and the person I was referred to, I understand that they would have done an evaluation, I think, right at the end of the 50th year. But so again, as of now, that's not public, but I would want, for us to consider having independent evaluation every 3 to 5 years, so that this can be reported, and again, that the public has access to it. We can see how the program is aligning with the restorative justice approach. We can see the youth behavioral outcomes. We can, draw inferences as it relates to victim engagement and satisfaction, and of course, costs. So how is it in terms of a cost-effective, from a cost-effectiveness standpoint, and then we can look at long-term recidivism. So thank you for allowing me the opportunity to share my recommendations.
Yeah, thank you very much, Mr. Christian. I don't know if people are aware, but we do annual reporting. But the point is that from both the Coalition for Healthy Society, they're recommending that we should table the report in Parliament. I actually table in my annual an appendix in my annual sectoral debate. So if we look at the sectoral debate over the last many years, I have tabled the report from the child diversion, victim services, restorative justice. But perhaps we should look at doing a table of, say, the last 3 to 5 years, separately from my sectoral presentation. We will discuss that, members of Ministry of Justice. But you can be assured that we do table a regular report, annual report. Unfortunately, maybe people are not aware. It comes as a part of the appendices in my sectoral reports every year. Are there any questions for the two presenters, last two presenters? I want to thank you, both Mr. Dunn and Mr. Christian. Some of what you have said are recommendations which we will look at and consider. And you can be assured all the Ministry of Justice personnel are here. So to that extent, they are aware of the many recommendations being made. Okay? So you have a question?
Protocols observed. Good afternoon. I'm here supporting Young Downer. He made reference, he misspoke, and so I think he wanted to clarify that when he said diversion does more harm than good. That's not what he intended to say. So I just want him to get that opportunity to clarify.
Go ahead.
Sorry about that. So as I said initially, I misspoke. It wasn't intended for me to say.
I think we understood you.
But I mean as if the program does. It is good. The diversion program is good. I'm not going to lie, it is. But I do think the perception of young persons is that it does more harm than good. That's a perception, right?
But your presentation didn't give that impression anyway. So that's okay. All right. Yes, Mr. Christian.
Chair, just to quickly clarify, so I understand that you said that this is, reported, but as a matter of like public consumption, because probably everyone is not tuned into Parliament, I'm more recommending that this is something that is accessible like on the website and is promoted over social media, kind of to align with the age we're living in.
The concern, it is on social media. We put it on the MOJ website. So I think the concern is that we may well be able to separate, this and other reports, like we do, for instance, the Administrator General's report is attached, but we can put it in separately. The court report, we put it in separately, because these are huge reports, so we don't attach it to the sectoral report. We actually put them in separately. But the child diversion report might be 5 pages, so we don't necessarily put it in as a separate report. We attach it as a part of my sectoral presentation. I want to thank everyone who participated today, and even those who are present. I think we have had a good session, lots of recommendations, lots of matters to consider. So I want to thank you, and just to say our next meeting proposed is April the 22nd at 2 p.m., Wednesday, April the 22nd at 2 p.m., and Thursday the 23rd at 10 a.m. These are proposed dates which we will colleagues. So without further ado, I would like to thank you and adjourn today's Joint Select Committee at this time.